Why not Monday? Monday, 28. Oh, on request made by Mr. A.K. Talukdar. Learner Council. It's, you want it on the hearing day? Huh, okay, then we'll have it on 25th. Okay, okay, 24th, 24th. Okay, then you cancel the order. Mr. A.K. Talukdar, that the council that he has filed an additional affidavit this morning. So please to verify and place the report it. Is the matter of the motor pass. 14, 14 and 15. When do you want? When do you want? 4 weeks. Okay, on request made on behalf of Mr. A.R. Buyan, please stop for 4 weeks. He's going to be out for 4 weeks. Oh, item 16. Ah, yes. Have you informed the other side? Your good name, please. On request made by MK New, current counsel for the respondent 1 to 7. Respondents 1 to 7. Please the matter on 29. Next week. Okay, 29. Next week only 3 days are there. To 11 and 4.
May I please, Your Lordship?
Yeah.
Lordship, I beg to mention for listing of writ petition for admission, Lordship. Lordship, any date next week?
Okay, 6.
Bless Lordship. May I please, Your Lordship? My prayer is for listing two writ petitions, similar matter, area salary matter, Lordship.
6.
Lordship,
May please, Your Lordship. Lordship, I beg to mention for listing of a contempt petition, contempt case, Lordship. For 25th, Lordship.
Why 25th?
Lordship, there is some urgency, Lordship.
4th.
Lordship,
4th of
4th of November. Right, Lordship.
Lordship, I beg to mention for listing one suspension matter madam. For admission madam next week any date.
6.
Can it be on 4th madam?
No, 14.
Obliged, Lordship. Item 1 of daily list motion.
Lord, my senior colleague, Mr. Ken Chaudhary is on Lex and Court number 1, my lord. Lordship will kindly take up this matter after some time, my lord.
Original records
I called for you.
have been produced.
Just after some time, my lord.
Original records have been produced.
Oh, you have got it
Yes, your lordship.
after some time.
After some time, my lord. My lord.
So, getting application.
Mr. Ken should be on later, for the finding.
Lord, I don't have any difficulty in accommodating, my lord. The only thing is I may get stuck up somewhere, then your lordship will accommodate me, my lord.
We'll adjust it. For the time.
And my lord, my further submission is that, my lord, the application has been filed for vacating the interim order. My lord, the time it will take will almost take the time of disposal of the entire writ petition. And my lord, they have also filed their affidavit in opposition. So my priority, my lord,
We take up the whole writ petition.
even if it is taken up,
Occasion, my lord, that was the direction of this one, my lord, verbal direction. That the entire matter will be disposed of today itself. Matter is urgent, my lord. So
no, my lord, it was insisted.
Instead of for the timing, the matter may be adjourned, my lord. Mr.
It was
Ken,
insisted by
will lead
Mr.
me
K.
in
N.
this
Chaudhary,
case.
my lord. I made the same submission on the previous
The
occasion.
last occasion, this honorable court has directed.
No,
that
there is-
the entire matter will be taken up on this day.
No, that is not the direction, my lord.
Verbal direction. my lord,
I made the my lord, submission that the entire matter should be disposed of. Then he said, no, I'll be insisting on the interim, vacating of the interim prayer.
My learned senior friend has submitted on last occasion, my lord, that the entire matter should be taken up.
Yes,
So, my lord, today, my lord, no problem, my lord.
Okay. Then we'll consider the whole writ petition.
My lord. Most of it.
only my lord, if I am stuck up somewhere, your lordship will kindly accommodate me.
Thanks.
God bless.
Pre-admission, part of me.
Hi, sir. Lordship, can you be the sometime that your lordship? You guys are supposed to place a report.
The mic working or not?
ওচৰত লোৱা ৰঙাটো একটু বেম কৰা তেতিয়াহলে
Now, after some time, Lordship, I'll just have to give a print out, your Lordship. Just now I received the instruction.
also bring also that for heavy ময়ো পাইছো কপি আনিছো
Or
Lordship, this is matter for disposal, my lord. The respondent who is, my lord, Puelis Junior to me, has been transferred to my school and holding the post of headmaster, my lord. Lordship may say the imprint order, which is at page, my lord.
Yes, correspondence side. You have been correspondence side.
No, no, no.
But yesterday they have filed an affidavit, Lordship.
When?
Yesterday, we have received a copy, Lordship.
What affidavit?
Their affidavit, the number is fine.
The stand is, there is nothing extraordinary they've submitted, my lord. The stand is same of the government, my lord.
So
So
that affidavit.
I've got extra copy, my lord. Last order, they have asked to submit well in advance, but they submitted yesterday only.
Respondent number one.
One. The Karbi Anglong is the main party, my lord.
And who's respondent by?
Respondent 5 is the present, my lord, headmaster of Longleat High School, my lord.
Okay.
Was not, yes, my lord.
Who's appearing for respondent five? Last occasion is one B Chakravarti.
Last occasion, my lord. She is the, my lord,
MS Sharma appeared on behalf of D Chakravarti.
yes.
Yes, that's okay.
they took time last occasion to file affidavit.
Correct. Yes.
And after 2 years, they filed the affidavit, my lord. I'm deprived of my lord, position, my lord, because a person who is 12 years junior to me is holding the post of headmaster in my school, my lord. That is the real crux of the issue, my lord.
Let us do one. We wait for some time. Let us get all of let your junior get all of what
My lord.
this beach property.
Beach. Respondent five. Fine. Beach. Huh? I think 5 has come. No, respond number 5 is Miss Bobita Inti.
You are challenging our appointment.
Yes, yes, madam. Because
Five
she
is
is
to be heard.
transferred from the different school to my school, madam, which cannot be, my lord. And there is no selection process, nothing, except on the basis of proposal made by inspector of school. There is no selection list, madam.
Wait for some time.
My lord.
Get hold of this.
I will.
5 and 6.
Lordship, meter may be taken after some time.
Why?
Lordship, Mr. S. Gotagur is lagging.
We have not filed our affidavit, so my lord, some time is required to file the affidavit, my lord. It is a matter of seniority, my lord. Some time is required.
Okay. Heard, mister?
I hawk your lordship.
I
Hawk your lordship.
hope Learned Council appearing on behalf of Mr. Bhattakur.
Yes, sir.
Learned Council. How much time you require?
3 weeks, my lord.
On request made by Mr. U. Shah, Learned Standing Council,
Secondary education
secondary
department.
education, 3 weeks time is allowed.
Lordship, interim was there.
To file contract.
All the respondents.
Please, after few,
Lordship, interim was there. It will contain.
few motor percentage to continue. Till the next.
Available.
Eight and 9 order.
He's on the way. After some time.
Where is he?
He's on the way.
On the way.
Yes.
When did he start?
And the exponent.
Oh, he has come. Thank you. We conclude today.
My lord. Today it can be concluded, my lord. In the affidavit filed by the official respondent, my lord, the director, they have raised my lord, 3 objections.
Where's the affidavit? Where did you file your affidavit, Dax?
Filed on, in writ petition 458023, I have filed on
That's from
dated 25/7/2024.
page 104, my lord.
1 minute. 4580.
4580, filed on 25/7/2024.
Yes.
Well, they have raised 3 objections, my lord. First of all, my lord, they said that, my lord, I received the graduate scale of pay with effect from 1/4/2017. 16.
Where is that?
my lord, paragraph 5, page 106. And in paragraph 6, my lord, last line, after amalgamation, the petitioner has been serving as assistant teacher in intermediate scale of pay.
No, one minute. Where? Paragraph six.
Paragraph 6, last line, my lord. On page 106, my lord.
I don't have 106.
The affidavit filed by the director, my lord.
Respondent, isn't it?
Yes, my lord. Respondent.
It starts on page 95.
My lord, in my
Review to go.
in the review, my lord, in my copy, my lord, it starts from page 104.
No, I want the read petition.
Read petition.
No,
45.
Lordship will take up the review
No,
petition.
no, the counter is finally in the read petition, isn't it?
Yes,
No,
your
no, in the
lordship.
review petition also they have filed.
Review,
As your
earlier,
lordship was
your
hearing-
lordship, review petition has been filed, your lordship, in form of affidavit. Then your lordship, again, there is a question raised in read petition. So again, we have to file for read petition also.
Okay, then in the review also you
Review,
Yes,
review.
your lordship.
When did you file?
It was filed on 27,
27/8/24.
Page
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 106, my lord.
106.
106.
Stop paging is wrong.
Paragraph 5 of the affidavit filed by the respondent, 5, 2, my lord.
Yes.
Paragraph 5, they have said that I received graduate scale of pay with effect from 1/4/2016. Paragraph 5, lordship got it?
Yes.
Then my lord, paragraph 6, last line. After amalgamation, the petitioner has been serving as assistant teacher in intermediate scale of pay. That statement is not correct. In paragraph 5, they said I received graduate scale of pay with effect from 1/4/2016. And school was amalgamated in the year 2018. And after amalgamation, my lord, I cannot serve as intermediate, my lord, assistant teacher in intermediate scale of pay. But this question of getting graduate scale of pay with effect from 1/4/2016, I have replied. I have filed a rejoinder, my lord. So should we kindly turn to page 125. The background of the conferring graduate scale of pay to the graduate degree holders working in ME schools, my lord. Page 125.
Para?
My lord, page 125, lordship got it, my lord.
Huh.
My lord, this is the letter, my lord, sent to the secretary chairman of Assam Pay Commission.
One. Is it an annexure?
Annexure, my lord.
128.
125.
Annexure 1.
Annexure 1, my lord. R1.
R1.
Yes, my lord.
Oh.
R1. This is the proposal, my lord, sent to the Pay Commission by the government, my lord. I am directed to forward here with the memorandum to be submitted to the Assam Pay Commission 2008 for considering graduate scale of pay to graduate assistant teachers serving under middle upper primary schools under Director of Elementary Education, Assam. This was the proposal. Well, the memorandum, lordship will find at page 126. Well, this decision of conferring graduate scholar pay to the graduate incumbents working in any school was taken pursuant to this honorable court's order. Page 127, my lord. Fourth paragraph. The All Assam Middle Graduate Assistant Teachers Kalyan Samiti has submitted WPC so and so before the Honorable High Court, and the Honorable High Court ordered dated so and so as follows. This is the direction of the Honorable Court, my lord, to consider the conferring graduate scale of pay to the arts graduate and other graduate teachers as it was given to the science graduate teachers. And last paragraph, page 128. Page 128, my lord. The proposal is put up to Pay Commission 2008 for granting graduate scale of pay to graduate assistant teachers serving under upper primary schools under the Directorate of Elementary Education, Assam, in the form of upgradation of scale of pay, rupees so and so, which is enjoyed by the science graduate teacher in upper primary school, Assam. So, well, the proposal was sent to the Pay Commission. What the Pay Commission did? The Pay Commission, my lord, they initially conferred at page 130. Earlier, my lord, the assistant teachers working in ME schools, they were termed as, my lord, intermediate teachers. They have termed, for the first time, they were termed as graduate teacher. Trained and graduate teachers. Has you got it, my lord? Page 130. Pay band was same, 5,200 to 20,200. And my lord, the grade pay was initially given to 2,300. It was revised subsequently pursuant to, my lord, approval of the government by notification dated 19/2/2011. Page 131. 131. 2,300 was upgraded to 2,700.
Where?
Page 131, my lord. The grade pay. Pay band was same, my lord. Pay band was same.
Serial number 9.
Yes, my lord. Serial number 9.
Oh.
2,300 was upgraded to 2,700. And the petitioner was initially given the grade pay, page 132, my lord. Initially, he was, after completing the, my lord, DLED training, he was given the graduate scale of pay, and pay band was 5,200 and the grade pay was 2,500. Initially, it was given to the petitioner. Subsequently, my lord, pursuant to the revision at page 134, page 134, the pay band 2,700 was given to the petitioner with effect from 1/1/2012.
1 minute. Yeah.
1/1/2012. So, my lord, the petitioner is receiving the graduate scale of pay meant for the teachers in ME schools with effect from 1/1/2012. 1/1/2012. They were termed as graduate teacher. They were given the graduate scale of pay, though it was lesser to the graduate skill of pay paid to the assistant teachers working in high school, but they were given the graduate skill of pay, my lord. Second, got the one, my lord. My lord, the second objection raised by the department in paragraph 9 that my B.Ed degree is not a valid degree as it was obtained through paragraph 9.
Yes.
ODL mode. As it was obtained through ODL mode, so they cannot consider my B.Ed degree as a valid degree. That was their objection. Now, Lordship may kindly turn to page 138. I obtained a B.Ed degree from Jamia Millia Islamia University. This is the recognition by the NCT 138. Center for Distance and Open Learning. This is ODL mode, my lord. Jamia Millia Islamia, Jamia Nagar, New Delhi, submitted an application to the Northern Regional Committee of National Council for Teacher Education for grant of recognition to starting B.Ed course, Open and Distance Learning System of 2 years from academic session 2003-2004, with an annual intake of 500 students in terms of section 14(1) of NCT Act. Well, paragraph 3. Now, therefore, in exercise of the powers vested under section 14(3)(a) of the NCT Act 1993, the Regional Committee hereby grants recognition to Center for Distance and Open Learning Jamia Millia Islamia Jamia Nagar, New Delhi for B.Ed course Open Distance Learning System of 2 years from the academic session 2003-2004 with an annual intake of 500. The NCT has granted recognition to Jamia Millia University to confer B.Ed degree through ODL mode. This is the recognition on 9th November 2003. Next paragraph, page 141.
Here.
Status was questioned, recognition question status. So, this was the clarification given by the regional director. With reference to your letter dated so and so on subject mentioned above, it is informed, certified that Center for Distance and Open Learning Jamia Millia Islamia Jamia Nagar, New Delhi was recognized by order dated so and so for conducting B.Ed course of 2 years duration from the academic session 2003 with an annual intake of 500. This recognition stands valid till date. Now, the territorial jurisdiction. The University Grants Commission has, my lord, clarified that point.
Now, what are you trying to say?
My lord, I am trying to say that the B.Ed degree conferred by the Jamia Millia University to the petitioner through ODL mode is a valid degree. That is why, my lord, I have brought these documents on, my lord, ODL mode, Open Distance Learning mode, my lord. Online distance learning mode, madam. Online distance learning. Now, the question of territorial jurisdiction came, this was, my lord, clarified by the UGC. This is in reference to a letter number nil dated 31/7/2018. I am directed to inform you that the Jamia Millia Islamia being a central university and as per the provision of its act, statutes and ordinance, of the act of the university, the territorial jurisdiction of Jamia Millia University is all India. So, my lord, Jamia Millia University can confer a B.Ed degree all over India through, my lord, ODL mode. And, my lord, subsequently, my lord, at page 143, the recognition was continued. Now, Lordship may kindly turn to page 149. Page 149. What the department says about the B.Ed degree obtained through ODL mode, my lord. With reference to the subject cited above, I am directed to inform you that many teachers are working in secondary schools under Education Department, Government of Assam, without pre-service training, and the number of in-service untrained teachers is around 22,387 numbers approximately, which constitutes 39.35% of in-service trained teachers, and the number of in-service trained teachers is only 15,424. The training of the in-service trained teachers is highly essential, and in this connection, NCT New Delhi filed letter number so-and-so has submitted the list of recognized universities, institutions which are offering B.Ed course through ODL program. The list of recognized universities is enclosed as Appendix A1, A2, A3, A4. The B.Ed course is highly essential and is requirement as per existing service rules of Government of Assam and the NCT regulation in force. And the in-service untrained teacher has to be trained to deal with the teaching curriculum and also to improve the teaching learning process through providing quality education, and accordingly, DSC Assam and all inspector of schools of the districts are requested to take immediate steps and motivate the untrained in-service teachers to pursue B.Ed course through ODL mode from universities as listed in Appendix A1, A2, A3, and A4. Immediate steps should be taken on the matter with due compliance report to the government. Now, Lordship may kindly turn to page 150. This is, my lord, Appendix A1. And Jamia Millia University is serial number 2. So, my lord, the Government of Assam has also recognized the degree of Jamia Millia University conferred through ODL mode. And I have obtained the degree from Jamia Millia University on ODL mode, and it is a valid degree. That cannot be said to be a invalid degree. The other question raised that, my lord, the B.Ed degree was obtained by the petitioner, my lord, without the approval of the appointing authority in violation of Rule 13 of Assam Services Conduct Rules. That question has also been answered by this Honorable Court at page 155. 155. Facts Lordship will find at paragraph 8. Page 158, my lord. Mr. U. Sharma, Learned Standing Counsel for the Higher Education Department, submits that the petitioner is a graduate teacher to the said higher secondary school, obtained his master degree in arts education from IDOL in distance mode in the year 2019-21 without obtaining NOC from appointing authority. He further submits that petitioner has obtained the NOC from the principal of the PB Dhirudatta Higher Secondary School, which is not permissible under rule under clause 13 of the Assam Services Conduct Rules 1965. Therefore, he submits that the master degree acquired by the petitioner is found to be not in accordance with the rule of 1965, although he is senior only on the basis of receiving so and so. Well, this is the question raised, whether by obtaining permission from the head of the institution, a teacher can obtain any degree through distance education mode. And this has been clarified at paragraph 22. Page 164.
Yes.
Having regard to the stand of the state respondents that the petitioner acquired his master degree in education from IDOL Guwahati University in the year 1920 to
164.
164.
Oh.
164, paragraph 22, my lord.
One.
Paragraph 22, my lord, of the judgment, my lord.
Okay.
My lord. Last line, my lord. Having regard to the stand of the state respondents that the petitioner acquired his master degree in education from IDOL Guwahati University in the year 2019-20 to 2020-21 without obtaining NOC from the appointing authority, which is not permissible under clause 13 of the Assam Services Conduct Rules 1965. This court fully in agreement that such stand has been duly considered in other proceeding by the coordinate bench of this court in WBC so-and-so, white order there so-and-so, relying on the earlier order of this court in the case of Srimati Mousami Shahoria versus Srimati Rekha Kolita and 3 others, whereby it has held that if a degree has been obtained without prior permission of the appointing authority, the same would be a misconduct under Rule 13 of the Rules of 1965, and it being a misconduct, the relevant proceeding of law applicable against the candidate would be a proceeding against such candidate under Assam Services Discipline and Appeal Rules 1965. But the same by itself cannot invalidate the otherwise valid degree obtained from respective universities, and further, the degree obtained from a university is governed by Section 22 of the University Grants Commission Act 1956. In view of the order of the coordinate bench of this court, this issue is no longer res integra, and in my considered view, the same is squarely applicable in the present case. There is no dispute that the petitioner has granted the master degree in education, and the said degree having been obtained from an institution recognized by the University Grants Commission. The respondent authorities do not have the jurisdictional authority to invalidate the said degree obtained by the petitioner, and such invalidation cannot be done even impliedly. That apart, on a pointed query to the Learned Council of the Secondary Education Department, to the effect that whether there was any proceeding or consideration before issuance of the impugned order dated so-and-so, to which the Learned Standing Council fairly submits that there was no such consideration or proceeding before the passing the impugned order dated so-and-so. Thus, the stand taken by the state respondents that the petitioner has obtained the master degree without prior permission from the appointing authority under Rule 13 of the Rule of 1965 is nothing but only in the grave of explanation without there being any material basis, which is not permissible under law. More so, such a stand has already decided by this honorable court. So, my lord, if I have obtained a B.Ed degree without permission from the appointing authority, it is open to the authority to initiate any disciplinary proceeding against me. Till date, no proceeding has been initiated. Till date, no proceeding has been initiated against me. And I have a valid degree. B.Ed degree is valid, as I have I have said that, my lord, in the documents, the NCT has granted recognition to the Jamia Millia University. Jamia Millia University has territorial jurisdiction all over India. So, my lord, my degree is a valid degree that cannot be said to be invalid, and that should be considered for the purpose of promotion to the post of headmaster, my lord. Now, they have the inspector of schools, while, my lord, considering the case for promotion to the post of headmaster, he submitted a, my lord, pro forma before the screening committee at page 168. 168. Monwar Hussain, my lord, the petitioner. Serial number 7, my lord. Date of receiving graduate, joining as graduate teacher. Date of joining as graduate teacher. It says that 1/1/2012. Then, my lord, serial number 8. Date of receiving graduate scale of pay. 1/1/2012. This was considered, and a provisional graduation list was published, my lord, at page 169. 169, and my name was placed at serial number 55. Page 171.
Yes.
55. Thereafter, my lord, here also, my lord, my date of receiving graduate school of pay has been reflected as 1/1/2012. Thereafter, the private respondent, my lord, though he is not eligible for the post of headmaster, he submitted an application at page 176 before the inspector of schools. So, my lord, considering his application, another provisional list was published. That is on, my lord, 22/7/2024 at page 177. This time, my name has been placed at serial number 152 on 82, my lord, page 182. And date of receiving graduate school of pay has been reflected as 1/4/2016. (152). This list is also, my lord, provisional graduation list. This is also not a final graduation list.
Has a final seniority list published?
Not yet been published, my lord.
Till now.
Not yet been published.
Have you made your objections to this?
I have made the objection. I have made the objection, my lord. My lord, I have explained about the graduation list at page 118, paragraph Roman 6, my lord. Roman 6. that the headmaster of Tilapara High School issued the NOC in favor of the deponent to pursue the B.Ed degree through ODL mode on 5/4/2018. Accordingly, the deponent took the admission in Jamia Millia Islamia and completed B.Ed degree course from the said university. The Honorable Court by judgment and order dated so and many other cases held that B.Ed degree obtained without approval of the appointing authority cannot be held to be invalid. As such, the deponent is holding a valid B.Ed degree and he is qualified to hold the post of headmaster in a high school. Accordingly, the Inspector of Schools DDC Dhubri published a statement showing the name of the deponent as eligible teacher for promotion to the post of headmaster under Dhubri district. Thereafter was 6/7/2024. A provisional graduation list was published whereby the deponent was placed at serial number 55, showing the date of receiving graduate scale of pay as on 1/1/2012. Thereafter, respondent number 5, though he has no locus standing, submitted an application dated 11/7/2024 before the Inspector of Schools, and on the basis of the application of the respondent number 5, a second provisional graduation list was published on 22/7/2024, whereby the deponent was illegally placed at serial number 152, showing his date of receiving graduate scale of pay as 1/4/2016. The deponent immediately raised his objection against the provisional graduation list dated 22/7/2024. Accordingly, the document verification was done on 31/7/2024, and during the document verification, on perusal of the service book and other related documents of the present deponent, it was found that the deponent received graduate scale of pay with effect from 1/1/2012. Thereafter, the final graduation list was prepared, fixing 1/1/2012 as date of receiving graduate scale of pay in respect of the deponent. That said graduation list is yet to be published. They have prepared the list, but it has not been published. After considering my objection, they have held that I have received graduate scale of pay with effect from 1/1/2012. This is my lord, the other aspect, my lord. As per the rule, for promotion to the post of headmaster, B.Ed degree is a compulsory degree. One has to obtain the B.Ed degree for promotion to the post of headmaster. The private respondent herein, my lord, he does not have the B.Ed degree. So, my lord, he has no locus. He has no locus to question my selection as headmaster, because otherwise he is not qualified for the post. So, my lord, if he is not qualified, on that point, my lord, I'll be relying on some decision of the court, my lord. एक मिनट होगा। Well, 2001-10 SCC 447, Muhammad Safi Pando versus State of Jammu and Kashmir and others. Small judgment, my lord. In paragraph 2, the long paragraph, and my lord, the relevant portion is in the second page, my lord. Further, you got it, my lord. Further, the appellant did not possess the minimum qualification required for direct recruitment, namely so and so, and therefore he was ineligible for being considered as a direct recruit. In view of the matter, he had no locus standi to assail the appointment made in favor of the others who, pursuant to the advertisement, did make application and did possess the requisite qualification and ultimately got appointed. As he has no qualification, he cannot question my selection, my lord. And 2010-15 SCC, Rameshwar Das Mahia my lord, paragraph 3, subpara 1, my lord. A court could examine the legality or otherwise of a matter only at an instance of a person who is qualified and eligible and has a locus standi, and not the one who has no eligibility. This is the vital line, my lord. So, my lord, the respondent number 5 does not have the locus standi to question my selection. So, my lord, as I have referred to the proposal of the state government, as well as the finance, the pay commission's report, the petitioner has obtained the graduate scale of pay with effect from 1/1/2012. He has completed 10 years of teaching experience. He has completed 10 years of teaching experience. He has the valid B.Ed degree, and he is qualified for the post of headmaster. And therefore, my lord,
You are saying you got your graduate skill from 1/1/2012.
2012. And therefore, my lord, the order at page 84 of the review petition paragraph 3, my lord.
Yes.
It must be brought on record that neither the petitioner nor the respondent number 5 is eligible to hold the post of headmaster in charge in terms of Rule 14(2) of Assam Secondary Education Provincial School Rules 2018, inasmuch as both of them has not completed 10 years of teaching experience, and the respondent number 5 does not have the B.Ed degree, whereas the petitioner has B.Ed degree. It is admitted fact that the respondent number 5 is senior to the petitioner. He is not senior, madam. His service was provincialized with effect from 1/1/2013. And I received graduate scale of pay with effect from 1/1/2012. My lord. And paragraph 4, my lord. However, considering the fact that both the petitioner and the respondent number 5 has not completed 10 years of teaching experience, and also respondent number 5 does not have B.Ed degree, the appointment of respondent number 5 as headmaster in charge of Tilapara High School District so-and-so cannot stand scrutiny of Rules 2018. So, my lord, that part of my lord, non-completion of 10 years of teaching experience may be required to be reviewed, my lord, in view of the provisions I have referred to your lordship. As he has completed more than 10 years of teaching experience as graduate teacher, as he has received graduate school of pay with effect from 1/1/2012, lordship may be kind enough to review the order, holding that he has the requisite qualification and teaching experience. It is my limited submission before lordship.
What is there in the writ petition?
My lord,
In your writ petition,
in writ petition, my lord, subsequently what they have done
after this order,
after this order, without considering the order passed by this honorable court, they have appointed the private respondent as, my lord, in charge headmaster again.
where is that order?
That impugn order also will find at page 93. Lordship's order was not considered. They have passed this order, my lord, without considering the case of the petition, my lord, petitioner, and also, my lord, without considering your lordship's direction. So, my lord, this order cannot stand. There was also, my lord, he is not qualified to hold the post of headmaster even on in charge basis. In the order, my lord, there is no reference to the lordship's direction. Lordship directed the director, my lord, to pass a speaking order, considering entire aspect. He did not consider the direction of this honorable court and passed this impugn order, my lord, in favor of respondent number 5. Bless.
Yeah, pleases your lordship. Pertaining to review petition, your lordship, we have filed our affidavit, your lordship. Your lordship, I would like to take you 106 page number, paragraph 5. I'd like to read your lordship.
Your affidavit is page
106.
yes.
I would like to read your lordship, paragraph 5. That the answering deponent humbly begs to state that thereafter the petitioner, that is Monwar Hussain, who is the present petitioner, service was regularized against a vacant post of assistant teacher of upper primary at a fixed pay of rupees 2,000 per month, which is likely to be revised, and subject to have undergone that senior basic training, normal training under the Assam Elementary Education Provincialized Rules 1977 and as amended in 2005, as required for upper primary teachers in intermediate scale of pay, and the petitioner also avail graduate scale pay with effects from 1/4/2016 as per government notification, White Government Order Memo so and so, dated 31/7/2018. That has annexed it as Annexure 1. Dated page 112, it was issued, your lordship. Very below, page 112, Annexure 1. 31st July 2018, your lordship. That was, your lordship, issued on 31 July 2018, which I have annexed it in exercise order by the governor notification. That is on Annexure 1, page.
Is there a specific order allowing the petitioner to get a graduate scale of pay from a specific date? Any specific order was passed
Your lordship,
with regard to the petitioner?
as per your lordship, instruction, your lordship, I have annexed it, your lordship, particularly to that question, your lordship.
Any instructions?
I need to obtain instruction whether any particular order has been
This is a
issued upon him or not.
final order.
Yes, your lordship.
But
That-
normally a particular order is also always issued granting graduate scale of pay to so and so, so and so.
I need to obtain that instruction, your lordship, whether that has issued upon the petitioner or not, that particular letter of issuance has been issued upon a petitioner or not. That I need to get it, your lordship, to obtain instruction, your lordship. As right now, your lordship, I don't have any particular issued letter issuance, your
But
lordship.
do you have any, any specific order issued to the?
In compliance of that particular service book, my lord.
The school authority has issued the order. The consequential order, that lordship will find it, page 64 of the review petition. Page 64. And that notification is not to challenge. Page 64. Under the notification, Lordship, got it, page 64, annex 9. Under the notification number so and so, gov letter number so and so, 48/2018. My learned friend has just read out that notification, Lordship, 48/2018. The fixation done as per table number so and so in the grade pay of scale of 8,700. Now, this is this grade pay of a graduate teacher who is serving in a high school. The only here, Lordship, the moot question is from which date the review petitioner receiving the graduate scale of pay mean to a graduate scale of pay who is serving in a high school. The admitted fact is that although he is saying that with effect from 1/1/2012, I am drawing the graduate scale of pay or a graduate teacher. He is a graduate teacher, he is serving in a ME school. And the graduate scale of a graduate teacher serving in a ME school is a lower scale than the graduate scale of a high school. That is the only question here. Here only after the revision of 2010 ROP rules that was revised in 2017, March 2017, and effect is given 1/4/2016. So that is why after revision of 2010 ROP rules, only in 2017, this petitioner was allowed to draw the graduate scale of pay meant for a high school teacher, which is equivalent to the respondent number 5. That is the only issue. And so far regarding the validity of BEd degree, validity of the graduation list, these are not Lordship at all required to be considered here. Because here the asking for review of the order, which was passed at his instance. He was present, it's a consenting order. And today he is seeking for review against that particular Lordship's order of 2023. Lordship, kindly hear my learned friend, hereby submit.
I think I've heard you.
Yes. This is the only answer. From which date, the issue is from which date the petitioner is allowed to have a graduate scale which is meant for a graduate teacher of a high school. Here, Lordship, it is only after the amalgamation the petitioner came to my school or a high school. So before that, from which that he is receiving graduate scale which is meant for a high school teacher. It is only 1/4/2016. There is no any denial that she is not or he is not a graduate teacher. Yes, he is a graduate teacher who is serving in a ME school. And the Minaram Kumar judgment itself says the graduate teacher scale serving in a ME school is lower than the graduate teacher of a high school. Paragraph 22.
Judgment is where? You
Lord-
finish a copy, isn't it?
Yes.
Is it just for this one?
I have found a copy of the order. In paragraph, no, judgment to be.
But 2014 2 GLT 480.
One minute.
Para 20.
1 minute.
Yes.
Minaram,
And other things are irrelevant not.
Minaram,
Minaram Kumar, 2014 2 GLT page 480, paragraph 20. I think. Who is eligible, who is not eligible, that will decide by the court. Here issue is not regarding the selection. Here issue is paragraph 20. I'm reading from this paragraph 20. Of course, my learned friend was the counsel from that particular point of time. May I read paragraph 20 onward? The submission of the learned counsel for the petitioner is that the above definition of graduate teacher does not include a graduate teacher of MS.
1 minute.
And
Para 20.
para 20. As such, there is no question of the.
Start with the above view.
No, para 20 is in the submission of the learned counsel.
Paragraph 19.
19.
Para
Paragraph 19. man.
Para 9.
Oh, sorry. May I read? The submission of the learned counsel for the petitioner is that the above definition of graduate teacher does not include a graduate teacher of ME school. At one point of time, it was his submission that ME school serving a graduate teacher cannot be included with the high school lordship. And as such, there is no question of the private respondent coming within the purview of graduate teacher to claim parity with the graduate teachers of a high school. So here is the same question, whether the ME school teacher can claim the parity with the graduate teacher of a high school. From which date? That is the only question to be decided here. It is further submitted by him that the experience teaching of an ME school gained by the private respondent cannot also be equated with the experience of the petitioner as a graduate teacher of a high school. To give parity of treatment of both the petitioner, who is a graduate teacher of a high school, and the private respondent, who was merely a graduate teacher of ME school prior to its amalgamation with the high school in question, would amount to underclassification, thereby negating Article 14 of the Constitution. In my opinion, this is important. In my opinion, I am relying this paragraph. In my opinion, this submission, though attractive at the first blush, does not really stand closer scrutiny. This is important. It is not the case of the petitioner that a graduate teacher of ME school has a lower pay scale than graduate teacher of a high school. But in the instant case here, in my case, the pay scale of the ME school teacher is lower because it is evident from the grade pay. His grade pay is 2,700 and the grade pay of the graduate teacher is 3,300. So I am coming to that ROP rules of 2010. So from difference of the grade pay or the scale, the ME school teacher drawing, although he is a graduate teacher, he is drawing the lesser pay scale than the graduate teacher of a high school. Or has lower qualification, then I skip lots of this paragraph. Now come to paragraph 22. In my judgment, of course, lots of here I'm holding the book. In my judgment, paragraph 21. The instant case is also one where the graduate teacher of ME school cannot be segregated from the graduate teacher of high school once their services have been amalgamated. More so, this line is important. When they have the same pay scale, the matter ends there. Now here, that is why I am repeatedly saying, from which date the review petitioner is drawing the graduate scale of paying to the graduate teacher of a high school. It is only 1/4/2016. That too also after revision of 2010 ROP rule. And when it was revised in 2017, it was revised, but effect is given 1/4/2016. So meaning thereby the grade pay of ME school teacher of 2,700 that has been enhanced to 8,700 only with effect of 1/4/2016. So from counting this date 1/4/2016, as per Rule 24(4), the review petitioner is not eligible to hold the charge of a high school teacher law. That is the answer. And regarding the revision of pay rules, the validity of B.Ed degree, validity of the recognition of institution, graduation literature, all are irrelevant. He is seeking the review of your lordship's order of 2020 only in one ground, saying that I am having 10 years of teaching service experience as a graduate teacher. But the answer here is, although he is a graduate teacher in a ME school, but he is not at par with the graduate teacher of a high school. That is the only answer. Now, what I am coming to page 73. The anomaly committee, their recommendation is automatically not given this benefit. Page 73. Could you be put on here? Now, this is the notification after revision of ROP rules 2010. Certain anomalies were there. So that matter was again placed before this anomaly committee. And ultimately, this recommendation made by the anomaly committee, and that notification lodge will find at page 73. Annex 13. May I read, Lordship? The first paragraph. The government of Assam has constituted an anomaly committee under the chairmanship of Shri so and so has skipping down this. 18th March 2017, the committee was entrusted with the task of examination of anomalies, if any, in the recommendation of 7th Assam Pay and Productivity Pay Commission, that 2077 pay. Government decision taken thereon. The anomaly committee submitted its report to the government on 31st December 2017. Now, the major recommendation of the anomaly committee along with the decision of the government are as follows. Now, here various departments are given. Now, so far the Department Education is concerned that Lodge will find at page 74. Now, this is the recommendation whereby that grade pay will be enhanced to 8,700. Education Department, page 74 at the bottom, serial number 9, Education Department 91. The anomaly committee recommended the following. Now, so far we are concerned here the ME, MB school, their grade pay is 8,700 as applicable to science graduate teacher. Now, earlier this was 2,700. It may be 2,700 of a scale of a graduate teacher serving in a ME school, but at that relevant point of time, the grade pay of graduate teacher of a high school is 3,300. That is the difference. And it is page 397, Lotse. I have already given the ROP rules of 2017. Page 2. I have given a copy of the 2017 ROP rule.
Page 136, my lord.
Page 397.
Yes, 397.
Yes.
This is ROP rules of
2017. Here, Lotse, both 2000, what was the scale in under 2010 and after revision 2017, what was the grade pay, everything is given, Lotse. Now, serial, Lotse, column number 5, this is the grade pay after revision. Page 397, I am reading from page 397.
Yes.
Lotse, 1, 2, 3. Assam School Service Class 2, Lotse.
Junior class 2.
No, graduate teacher of higher secondary school, high school. Under caption Assam School Service Junior Class 2. Would you kindly see what was the scale? 5,200 to 20,200 and 3,300. That's what I'm repeatedly submitting, that this is the grade pay of graduate teacher serving in a high school. And after 2017, this grade pay is enhanced up to 8,700. Now, at that relevant point of time, that is under ROP 2010, what was the graduate teacher's grade pay of serving in a ME school? 2,700. Next column, Lotse, Assam Lower School Service, teaching and inspection, ME, MB Senior School, graduate teacher. Payment to scale is same, grade pay is 2,700. Now, what I'm trying to submit that at that relevant point of time, before the revision of 2010, the grade pay of ME school is lower than the grade pay of a graduate teacher serving in a high school. Although he is a graduate teacher, and that is the difference what Meenaram Kumar also exactly reflected. It is my case is that the petitioner is drawing lower pay scale than the respondent number 5.
So with the ROP rules of 2017,
17,
this was
and then up to that is at par, that is
with 8,700.
8,700, and
Which
it is
was given to him with effect from
1/4/2016. So from that day, the review petitioner is equivalent or at par with the graduate teacher of a high school. That is the case here on. So counting that particular date, because this anomaly committee, also I am not finished that particular when the effect is also given, that Lord you will find at page 76 of the review petition, date of effect.
petitioner received from
1/4/2016. His scale pay meant for a graduate teacher serving in a high school. For whom the grade pay is 8,700. And he admitted that the service book itself reflects. Now, logically come to page 76, from which date effect is given. date of effect.
Yes.
The anomaly committee found no justification to change the date of effect of the recommendation of 7th APPC from 1/4/2016. So in bold letter it is written, general government agrees with the recommendation of the anomaly committee and upholds the date of effect 1/4/2016. So this is the case law here. And so far after this recommendation lordship, that notification issued 4th of August 2018, that lordship will find at page 77. Page 77. And pursuant to this notification, he is availing this benefit. He has not put to challenge. If he is agreed that I am not, it should be 12 instead of 1/4/16. He should put to challenge this notification. He is accepted all this. 4/8/2018, page 77. So ultimately, after that recommendation, this notification issued by the government, lordship, finally see trained graduate teacher. The first is existing pay scale and next column is revised pay structure. Now, what was the existing pay scale? 5,200 to 20,200 and grade pay is 2,700. Now, this is NS after 2017 up to the scale is now 14,000 to 49,000 and grade pay is 8,700. Effective 1/4/2016. So consequential order that lordship will find at page
Effective date, what is the effective date of this notification?
1/4/2016. Already I have shown the recommendation of the anomaly committee, page 77. So in compliance of that notification, government issued this notification. Now consequential order lordship will find page 64. Page 64. A reference is given of that particular notification of 4th of August 2018. Page 64. So this, by this, this was issued on 27th of 9/2018. Now this is done in compliance of that 4th of 8/2018 notification. Now let's see here see. Date from which, serial number 5, date from which the revised pay structure is applicable, 1/4/2016. Then let's see, revised pay structure is given 8,700, serial number 7, serial number 6 is the existing pay structure, other 2010. And initial pay fixation, serial number 12, 1/4/2016. So in view of this notification on the recommendation of the anomaly committee, as well as the government notification of 4th of August 2018, and Minaram Kumar's judgment of paragraph 20 and 19 and 20. The
Minaram Kumar said that when the grade pay are the same.
Yes, get pay same because the
Scale of
ME
pay
school-
same.
the ME school teacher can claim parity with the high school when the scale as well as the grade pay is same. Now here with only with effect from 1/4/2016, the scale of pay and the grade pay both are same lots. Yes. And the date is 1/4/2016. And so for the other submission, I think those are irrelevant here because his only ground for review of this 2022 order is he is having 10 years of experience as a graduate. My respectful submission is not. He has till date, he is not completed 10 years of teaching experience, counting the date of receiving the graduate scale of pay with the high school teacher. Graduate teacher of having a high school teacher. Because the date is 1/4/2016. This is my only submission.
Small reply, my lord. A small reply, my lord. Let us peruse the rule first, my lord. 2018 rule, my lord. Because my lord, the Minaram Kumar judgment was rendered on the basis of 2003 rules. In the 2003 rules, my lord, there was no provision for conferring seniority to graduate teachers of ME schools. But in 2018 rules, there is a provision inserted at page, my lord, 41, seniority, rule 24. I will directly take your lordships to the relevant provision. Rule 24. Minutes. Page rule 24.
1 minute.
Seniority. Rule 24, sub rule 5.
Yes.
In case of amalgamation of ME, MV, LP school with other higher secondary school, high school under the scheme of Shiksha Kshetra, the employees of amalgamated school shall be given seniority with effect from the date of joining on substantive appointment or regularization, provided that in case of graduate teacher, the seniority shall be counted from the date of getting graduate salaries meant for a graduate teacher. It does not say that it should be meant for a graduate teacher in high school.
But then that notification at page 64.
Yes.
Which gave you with effect on 1/4/2016.
Yes, my lord.
That
What?
you have accepted that notification.
Yes, I have to accept. My lord, what happened, my
You
lord?
have accepted
Yes, my lord.
that
No.
you will have to
Let-
count your seniority.
Let me explain, my lord.
2016.
My lord, in 2010 ROP, 2010 ROP, they were giving lesser pay scale, lesser grade pay, not pay scale. Pay scale is same, my lord. Pay scale is same. Lesser grade pay to the graduate incumbents working in ME school than that of the graduate incumbents in high school, as per the 10 ROP. That was again given by in the 2017 ROP also. Then it was placed before the anomaly committee. Anomaly committee found that anomaly, that this is not correct. The graduate scale of pay, if you are giving the graduate scale of pay to the ME school teachers also, then their grade pay also should be same. Pursuant to that recommendation, finding of the annual committee, the government decided to confer same grade pay to the teachers in ME schools also. And accordingly, my lord, under page 64, the grade pay of 8,700 was given to the petitioner as per 17 ROP. 17 ROP, not as per 10 ROP. You got my point, my lord? My case is that, my lord, as per 10 ROP, whatever was meant for graduate teacher in ME school, I was paid as per 10 ROP. And as per 17 ROP, under page 64, I was given the benefit of 17 ROP.
See, before the 2017,
Yes, my lord.
the grade pay of the ME school graduate teacher was lower.
Grade pay was lower, my lord.
Lower.
Grade pay was lower. And in Minaram Kumar's case, my lord,
It was equalized. It was equalized only by the ROP of 2017.
yes. Yes, my lord.
After the anomaly committee made its recommendation.
But the pay scale was same.
Oh, the pay scale is.
Pay scale was same.
grade pay
And
was-
in the case of Minaram Kumar, only the pay scale was considered, not the grade pay. Not the grade pay. Lordship is if your lordship comes to paragraph 21 of Minaram Kumar, in my judgment, the instant case is also one where the graduate teacher of ME school cannot be segregated from the graduate teachers of high schools once their services have been amalgamated, more so when they have the same pay scale. Pay scale is same, my lord. Only the grade pay was lesser in respect of the ME school teachers. It doesn't say the pay structure on total pay. It says pay scale. Pay scale was same. It was made for, well, in ME school and high school, their pay scales were same. Only grade pay was in respect of high school, 3,300, and in respect of ME school, 2,700. And that was found to be, my lord, not correct by the government. And government, by of their own, my lord, they have decided my lord, that my lord, it should be given equal to the ME school teachers also. And as per 17th ROP, they have given the benefit to the ME school teachers also, my lord, at par. So it cannot be said that I did not have the graduate, my lord, teaching as a graduate teacher. Yes, it doesn't say that, my lord, I was getting, whether I was getting a graduate scale of pay or not, whether I was a graduate teacher or not. This is the question. From what date I was a graduate teacher? But teaching experience is counted as graduate teacher. As my friend also admits that I was a graduate teacher with effect from 1/1/2012. 1/1/2012, I was a graduate teacher. If I was a graduate teacher with effect from 1/1/2012, even if I was getting a lesser pay, grade pay, my experience as graduate teacher cannot be, segregated from, the date of amalgamation. That experience when I was working in ME school, that cannot be deleted, my lord.
I'll come.
My lord.
Sir, I expected the council for the review. Looks like the standing council. For the respondents,
In review, your
the review. 1, 2, 3,
1, 2,
4. And Mr. A Decca, the council, what are the phone numbers?
5.
5.
In both the cases.
Carrying computer. That's what.
In both the cases, he responded.
Read petition also.
It's the same argument because this is the outcome of this review petition. And in fact, much in the affidavit filed by the review petitioner, he himself admitted that I am reading that particular line. Under the ROP 2017, the graduate scale of graduate teacher of high school and graduate teacher of ME and B school was made equal. So what else remains?
And so what will be for?
Deplorable.
This is not a report.
Actually, they don't have any other record, my lord. And my lord, the fact that they have not.
Where are the note sheets?
This is the only records, your lordship, I have obtained it from the
These are all
department.
these are all in photocopy.
Well, lordship will go by the Evidence Act. They don't have any record. That's why Evidence Act condition. 114H. Evidence Act condition. In a certiorari proceeding, if somebody does not come with the records, lordships will draw adverse conclusion.
This is not a report.
I have, your lordship, communication has been made, your lordship, as per the communication. This is the only report and.
On the last occasion, lordship has indicated that this is the last chance.
I said to produce the record in original. From where did you get this record?
From the department itself, your
Which
lordship.
department?
Secondary education, your lordship.
How can this be the record?
And on the, your lordship, tomorrow, your lordship, that 15/10/2024 report, inquiry report that has been sent to the petitioner, your lordship, that has given, your lordship.
What? Where is that?
Very first page, your lordship. Yes, sir.
Yes. Now the section 111, 114 H. And if 114 H. H. That if a man refuses to answer the question which is not compelled to answer, no. Sorry, G. Miller, that evidence which could be and is not produced would, if produced, be unfavorable to the person who holds it. They are not producing because they know it would be unfavorable. So presumption is adverse conclusion is to be done. G, 114 G.
No, it is H.
So
It is H.
both, my lord, G and H.
G and H.
Yes.
Yes. Yeah. Normally records. I don't know whether now you are having the E records.
Yeah, nowadays it is more convenient, my lord.
But then there's normally a note sheet
Yes.
where decision is taken on the basis of the decision taken in the note sheet. Notifications are issued.
Various time, your lordship, already communication has been made, your lordship, and they had hand over this only, your lordship, as per records. Submission of
Well,
records.
by their own showing at page 66. Kindly come to page 66, my lord. This is a record. Page 66, last para. Page 66. Due to last para, due to pendency of departmental proceeding, it has been decided to extend the period of suspension of Sri so-and-so, of so-and-so, for further 3 months with effect from 18/8/24. So it is beyond time, Miller.
Earlier, your suspension was
18/5/24.
where was that?
Page number, my lord.
24.
24. So review was done on 91st day and made effective from 92nd day. And in view of, my lord, the series of judgments, including Deepak Mali's case, so this is fatal. And moreover, my lord, under the Assam rules, the other day I placed, the whole idea is suspension is not a punishment. Suspension should be resorted to only when major penalty is likely to ensue. And what is the allegation against me, my lord? For the month of salary for the month of April was paid to two teachers as an in-charge principal on 17th of May. As the
Deepak Mali was para?
Para 10. Having carefully considered the submission made on behalf of the parties and having also considered the relevant dates relating to suspension of the respondent, when the petitioner's case came up for review on 20/10/2004, we are inclined to agree with the view expressed by the Central Administrative Tribunal as confirmed by the High Court that having regard to the amended provision of sub-rule 6 and 7 of Rule 10, the review or modification or revocation of order of suspension was required to be done before expiry of 90 days from the date of order of the suspension, and as categorically provided in sub-rule 7, the order of suspension made or deemed to have been made valid after a period of 90 days unless it was extended after review for a period of 90 days.
Was that discipline and appeal rules?
Rule 6.
Rule 6, isn't it?
Yes, madam. Page 29. Yes.
That review per area.
Yes, my lord, that's a manual of departmental instruction 2.1.8. If your lordship is having the, এখন কিতাপ আছে নেকি? Can my lord, the Assam Services Manual, the Manual of Departmental Proceeding, there is a part 2.1.8. Manual of Departmental Proceeding. Towards the end, I think it would be there. Yes, please come to 2.1.8. The following principles and procedures with regard to suspension need strict compliance. Suspension should be resorted to only in cases where major punishment is likely to be imposed if charges are proved. Now, what is the charge against me, my lord? There was delay of 17 days in paying salary. The director took personal initiative. She called me up, my lord. She abused me over phone. The charges and statement of allegations should be served within 3 months from the date of suspension, failing which the government servants should be reinstated in service. In cases where it is not reasonably practicable to prepare the charges for service within 3 months from the date of suspension, and continued suspension of the government servant is considered necessary in public interest, the authority concerned should move the personnel department to administrative department well before expiry period of 3 months with a letter detailing the nature of allegation and reasons for which charges could not be prepared, so that personnel department could advise whether any further extension of period of suspension should be permitted or not. In fact, my lord, Ajay Chaudhary is a judgment of 1919 or 20, whereas our state government circular out of this is of my lord 1979. That is OM ABP 284/79/1 dated 5th September 1979. So the idea is the administrative department will refer the file to the personnel department with the views, and personnel department will advise whether. So these are all procedural safeguards.
Give me that Ajay Chaudhary.
Yes, para 1921, my lord.
2000.
Ajay Chaudhary is 2015 7 SCC 291.
I'm not interfering with the departmental process.
No, that is not our prayer also, my lord.
But I'm interfering with the subject.
My lord,
I'll pass out.
Deeply obliged.
This one. Can take back to you.
Deeply obliged.
What do you want?
I paying for FR number 4.
Yes. Heard again, the bill in the senior council, assistant of Mr. Zeta. MS Peter.
This is the Michael of the latest.
Second page, part of the respondents. That's you are paying for
Secondary education.
one, 2,
1, 2,
3,
1, 2, then 3,
5.
5.
What are these 6, 7, 8, 9?
These are private respondent, your lordship. Additional teachers.
My lord, purportedly their salaries were withheld.
MS DT Barman and the additional state of. Yes, sir.
Deeply obliged.
Item 3.
One, two, three.
Number 3, I have given the report, your lord.
But in this case, my lord, petitioner was, an advertisement was issued in the year 1991, my lord. Then, yes, ma'am.
Where's the?
This one, my instruction plans, maybe.
Have you got a copy?
No. Copy is received till now. Copy is one. I think inspector school is good. They do it.
You can check up this list.
My lord, that copy is with me, my lord.
This copy you have.
Yes, my lord.
You got it now?
Not now, my lord. I have received from my client.
Okay.
It is shown that the person who is below than me, all are getting old pension, my lord.
What is serial number 1, 2, and 3? They are receiving NPS, your lord, under the new pension scheme. From the
1,
same
2, and
list,
3.
1, 2, and 3, your lord.
Why?
Lordship, because they were appointed after 1st of February 2005, your lordship. Because
And from 4 to 30.
One.
These are all. These are all the.
In my lord.
These are all in the list.
Yes.
They are
In the first select list.
Yes.
Let us see.
My lord, my serial number is 17, my lord. But the person who is, my lord, serial number is 25.
One minute.
Yes.
Let us see the select list.
the select list is at page your
Page
lordship,
21, my lord, 21. Serial number is 17. Petitioner's name is Gautam Thakuria, my lord.
starts from 20, your lordship, page 20.
Zetu dia nai, মোৰ constituency
You have a type copy.
I belong to Borama constituency.
You have a type
No,
copy.
no type copy, your
Type copy actually.
lordship, because of
And the
since-
person who is serial number 25, Ojit Deka, my lord, the last one, Ojit Deka, he got old pension scheme. My lord.
Can you give a type copy? I can't.
Yes, my lord.
Lordship, because the difficulty is that this copy is not legible, your lordship.
That is the
And that is the reason why we are not being able to give the entire, whether they have been appointed under
It
the
is not my
NPS
problem.
or.
Okay. MSK they will.
Type কৰি দিব লাগিব
Shall furnish a type
যিখিনি আমি দিছিলো
of annexure 2, isn't it?
yes my lord
Annexure I page 20 and 21.
20 and 21.
When can you furnish?
My lord, by tomorrow, then Lordship kindly next. Okay, dear Lordship.
When do you want?
Lordship, any date, your lord.
Any date, my lord.
29?
29.
No,
Highly obliged.
obliged.
Four.
I did an affidavit, but have not turned on the penalty.
He has given me a type, photocopy. When did you file it?
It's a deal.
Mr. Roy,
My lord.
let the original come. Sometimes if it does not come, then we dispose of the matter. Housing it lies in the defective section.
Then lordship may fix
Then
it
some
on
problem.
Thursday, my lord, this coming Thursday,
Okay.
Friday, Lord.
24th, no, Thursday, hearing day.
Mr. J. Roy,
Tomorrow or Friday, Lord. Thursday I have some difficulty.
assisted by Mr.
Rinko Jai.
Mr. B. Chakravarti, appearing to his phone that he has filed affidavit in opposition on behalf of his phone on yesterday's date. On 21st of which you verify. When do you want?
Tomorrow it is 23rd, my lord.
Friday, Lord.
24th, my lord.
Before that, I have some difficulty.
29.
Then you will have it on 29. You can take it.
But no, my lord. But my lord, no further opportunity, my lord.
Now they filed the affidavit. Only the.
My lord.
Two.
But then IA filed by us, my lord, praying for vacation of the expert interim order.
This morning when you were not there,
Huh.
Mr. Chowdhury was there.
Yes.
Mr. Chowdhury. Khan was there. There was an agreement that we'll go for a final disposal of the writ petition.
It takes
A
some.
suggestion was made.
Oh, Lord, there is, because why I'm saying, my lord, unnecessarily this man is drawing salary of about almost 3 lakhs rupees per month. And he has been, his service has been interfered with. Now, my lord, a notice has been issued in terms of the division bench order. They pray for time and they come to court. Please take my IA, my lord,
Which your
because it is an expertise order.
My senior Mr. M.K. Chaudhary. He's on his way. He's coming.
Yes,
coming?
yes,
Then can we go for final?
yes, why not?
In fact,
Yes.
subject to what my senior says.
Your senior, sir.
Yes. It's,
He's agreeable to final hearing.
Yes, my lord. Then I'll start. Today or any other day.
No, today, just now.
Very good. Very good.
My lord, Lords will kindly,
Okay.
final disposal may take some time. There's an expedient order. That's why, and this application was filed quite some time back. And because, my lord, disposal may take some time, therefore, I'll pray for pressing this IA, my lord.
My submission will be, my lord, the decision in the, my lord, I will be taking almost the same time as, my lord, the main writ petition. And I'm ready for the main writ petition, my lord.
Then
Had it been an intra-party order, my lord, I would have agreed. Since it is an ex-party order, my lord, university has some urgency in the matter, because they would not like to continue with a person whose services have been done away with unnecessarily because of this stay order. My lord, he is serving.
That's why, my lord, it's all the, my lord, necessary that the entire matter should be disposed of. Because, my lord, hearing the IA will.
They will go for final.
Okay, let him start.
Now, my lord, the impugn orders in this writ petition are at page 100 and 101. But before that, my lord, I'd like to take your lordship to the, my lord, the background of the case. Otherwise, my lord, going to the impugn order directly will not be, my lord, very clear about the position. Now, first, my lord, there was an advertisement by the, my lord, K.K. Hendig State Open University. I'll take your lordship to the, my lord, advertisement. Your lordship will find that page 27. This is an advertisement published in the Tribune, my lord. K.K. Krishnakanta Khandiko State Open University, and applications are invited for Indian citizens for the following posts. Your lordship will find, my lord, there are as many as 4 posts of professors. And the petitioner is concerned with this serial number 3, professor under Bhupen Hazarika School of Mass Communication, 1 post. And there are other posts also, my lord. Why I am, my lord, stressing on the other post? By the same selection process, the petitioner was selected and the other persons were also selected. Now, my lord, I'll also show from the other documents, but they are questioning the, my lord, the entire selection procedure. If the selection in respect of the petitioner is wrong, then, my lord, the procedure in respect of the other persons who have been selected and who are working, that is also wrong. And that, my lord, I have been singled out. That's why, my lord, I have drawn your attention to this particular, my lord, advertisement. Then, my lord, your lordship may kindly come to the next page. These are the, my lord, the first statute of the university. Chapter 6 of the first statute, my lord, the relevant provisions, I'll read only 2 or 3 provisions, my lord. Manner of appointment.
This is the first statute.
Page 28, my lord. This is the first statute of the, my lord, of the university. Krishnakanta Khandiko Open University, State Open University. Your lordship may kindly. My-
Yes.
Serial number B is the, my lord, manner of appointment. 1. The university shall advertise the post with such qualifications as have been prescribed in the ordinance. Then 2 is important. The applications received against each post shall be sent to at least 2 outside experts not connected with the university for assessment of their eligibility for the posts. So, my lord, after the advertisement, my lord, they will call 2 experts from outside the university for assessing the eligibility. Then, my lord, the serial number 3, if the list of applicants recommended by outside expert is not big enough, the vice chancellor shall have the power to shortlist such a candidate on merit. This did not arise, my lord, because there were only 3 applicants. Out of the 3 applicants, my lord, one did not have the qualification. So, only 2 candidates were there. Then, my lord, your lordship may kindly come to page 30. So what they did is, my lord, they had called 2 experts from outside the university. And this is, my lord, at page 30, your lordship will find, this is one of the, my lord, recommendations of the of a professor of Sikkim University. Now, this is only for the purpose of deciding, my lord, eligibility. I'll come to the eligibility conditions as have been laid down by the, my lord, University Grants Commission. Your lordship will see, my lord, assessment from subject expert, background information, name Dr. So-and-so, the petitioner. Your lordship may come to the, my lord, last paragraph. Although the applicant does not have the required teaching experience as assistant and associate professor and has not supervised research at PhD level, his experience in the industry and his contribution to the knowledge in the domain qualifies him to be considered for the post of professor under clause 4.1.3.b of the UGC regulation 2018. My lord, I'll take your lordship to that a little later. Then, my lord, the other expert is opinion your lordship will find at, my lord, page 27. 32, I'm sorry. 32. This is by a professor, vice chancellor of Prayagraj University, UP. Then your lordship may come to the last but one paragraph. Your assessment about the candidate, maximum 100 words. The performance of the candidate in the core subject area and applied field is appreciable. As per norms advertisement UGC regulation, he is eligible under category B to be called for interview. So my lord, two experts have held, outside experts have held that I am eligible to be considered for the interview. Now, my lord, your lordship may kindly come to, my lord, the clause 4.1.3.b of the UGC regulation 2018, that is annex, my lord. Say annex for this there. Minutes. It is there in the minutes, but I am giving a copy, my lord, from the UGC guidelines. UGC regulation 2018. My lord, it will be the third page, page number 60. Last paragraph, my lord. These are all eligibility conditions. Roman 3 is professor. Has your lordship got it, my lord? Eligibility A or B. So one has to satisfy either A or B. A is an eminent scholar having a PhD degree in the concerned allied relevant discipline and published work of high quality, actively engaged in research with evidence of published work with a minimum 10 research publications in the pre-reviewed UGC listed journals and a total research score of 120 as per the criteria given in Appendix 2, Table 2. A minimum of 10 years of teaching experience in the university college as assistant professor, associate professor, and research experience at the equivalent. This is A, my lord. These are for the academicians. Now, my lord, the petitioner fulfills the criteria B, because, my lord, I have already shown, my lord, either A or B. B is, my lord, may I read it? An outstanding professional having a PhD degree in the relevant applied disciplines from any academic institution not included in A above, industry, who has made significant contribution to the knowledge in the concerned allied relevant discipline, supported by documentary evidence, provided he/she has 10 years of experience. My lord, I also from the documents that, my lord, I satisfy this. And, my lord, in fact, the experts have also said that, my lord, clause 3B has been satisfied, therefore he can be called for interview. Now, what happened, my lord? If your lordship kindly comes to page 35 of the writ petition, this is the, my lord, proceedings of the selection committee. My lord, what they are trying to do now, my lord, I'll come to it later on. They want to have the proceeding once again. That is where, my lord, I am aggrieved at. Proceedings of the selection committee meeting for the post of professor in Bhupen Hazarika School of Mass Communication held on 21/12/2020. Members present. Now, your lordship will find here there are two experts, my lord, in the field, and, my lord, other persons. Then, my lord, paragraph below the chart, your lordship will read. Total 2 candidates were shortlisted and called for interview, out of which 2 candidates appeared in the interview. The committee, after taking into consideration the academic credentials, experience in ODL, research publication, and performance in the interview, unanimously decided to recommend the following candidate for appointment in order of preference. Number 1, Dr. Jayant Kumar Sharma, who is the petitioner.
ODL is
Open and distance learning, my lord. This is a, yes, sir. Because this is a, my lord, state open university. Now all the experts have signed there, including the registrar. Then, my lord, he was appointed, that is at page 36. He was appointed, my lord, on 24th of December 2020. Page 36, my lord, that is the order of appointment. Now, after this appointment, my lord, he was also confirmed. If your lordship comes to page 38, this is the, my lord, confirmation order. He was confirmed in service. As per approval of the Honorable Vice Chancellor, the service of Professor Jayanta Kumar Sharma, Director, Bhupen Hazarika School of Mass Communication, is confirmed with effect from 1/2/2022. The approval was apprised in the 66th meeting of the Board of Meeting held on 8/2/2022. So, my lord, as per procedure, he was also confirmed in the job. Now, my lord, what happened? Thereafter, there were three complaints made against the petitioner, my lord, one by a political outfit and one by another person who is not connected with the university and not, my lord, in the teaching also. He doesn't have any relation with it. He filed a complaint. And, my lord, one Dr. Srinath Burra, my lord, who was once upon a time Vice Chancellor, he also, my lord, filed a complaint against me to the governor, saying that, my lord, I was not eligible to be appointed. The selection is wrong. Now, out of these three, my lord, complaints, one is a, my lord, political organization, that is called, my lord, Hindu Yuva Chhatra Parishad. And, my lord, Dr. Srinath Burra, my lord, who had allegedly made the complaint, he had subsequently wrote to the governor that I did not file this complaint. Someone may have, my lord, copied my short signature. So I'll produce that also, my lord. So, my lord, there was something, my lord, working against him, which used the, my lord, political organization and one person, and also, my lord, one fake letter. So, on the basis of that, my lord, what they did, they had, my lord, held an inquiry behind me. And, my lord, a show cause notice was issued at page 39 on 3rd of April 2023 after the, my lord, confirmation. Confirmation of my service was in 2022 March. And April 2023, this show cause notice was issued at page 39. May I read it, my lord? It's a small, my lord, one paragraph later, issued to the petitioner by the, my lord, registrar. The registrar, my lord, who was there, my lord, I had already pointed out who was there in the, my lord, earlier selection committee when it said, my lord, I was selected. He issued this order. In response to the letter number such and such dated 22/12/2023 from the UGC New Delhi, a committee was constituted to examine your eligibility as professor in Bhupen Hazarika School of Mass Communication. So and so the committee submitted its report, which was presented before the Board of Management in its 70th meeting on 10/3/2023. The board resolved that action should be taken against you based on the recommendation of the committee. I am directed to know your opinion, my lord. I am stressing on this word. I am directed to know your opinion about the decision of the committee and the Board of Management within 10 days from the date of issue of this letter. So, my lord, an inquiry was conducted behind my back. The committee, my lord, gave a report against me. And thereafter, my lord, this show cause notice was issued. And, my lord, the report of the committee was there, my lord. So, what I did, my lord, this was a letter of dated 3/4/2023, my lord. Petitioner wrote a letter at page 49. This is report, my lord. I may come to the report a little later at page 40. Page 49, if your lordship kindly comes. Dates are very important, my lord. The show cause notice was issued on 3rd of April. I had written this letter on, my lord, on the next day itself, saying that I am in receipt of your letter referred to above. I have also received the photocopies of the 2 letters from the UGC addressed to you and photocopies of a 9-page report of the Commission on examination of the selection procedure and eligibility of Professor Jayanta Kumar Sharma, sent along with your letter referred to above. Please take note that those photocopies have not been authenticated to be copies of the original documents. There have been a reference to a number of annexures in the said report which have not been provided to me. The photocopies of the document provided to me may kindly be provided, again duly authenticated. Also kindly provide me with the duly authenticated copies of the annexures 3, 4, 5, 6, 7, 8, and 11 so that I can submit an informed and reasoned opinion about the decision of the committee and the Board of Management as sought by you. Moreover, you have informed that the Board of Management of Krishna Kanta Hendricks State Open University resolved that action should be taken against me. Based on the recommendation of the committee, I may also be provided with an authenticated copy of the resolution of the Board of Management. So this letter he immediately wrote on the next day. Now, my lord, what happened, my lord? They had, my lord, provided the documents on, my lord, 18th of April. That is reflected in the judgment, on the earlier judgment, my lord. On 18th of April, those are provided. Then, my lord, on 19th, without giving me any opportunity of filing my reply, they had issued this order of termination at page 50. In pursuance of the decision of the 71st page 50, I am reading, my lord. In pursuance to the decision of the 71st meeting of the Board of Management held on 19 April 2023 by the resolution number such and on the basis of the report submitted by the committee constituted for examination of the selection procedure and eligibility of Professor Dr. Jayanta Kumar Sharma, the service of Jayanta Kumar Sharma, Professor in the Bhupen Hazarika School of Mass Communication, Krishna Kanta Hendricks State University, is terminated with immediate effect. So, my lord, they issued a show cause notice, did not give me the papers, gave me the papers on 18th, on 19th, my lord, without waiting for my reply. They have terminated me. Therefore, my lord, I was constrained to approach this honorable court by filing a writ petition. That judgment your lordship will find at page 51. I'll not read the entire judgment, my lord. The operative part of the judgment your lordship finds at page 80. 58. Page 80. Paragraph 57 and 58, I'll read, my lord. Having considered the materials on record and in the light of the above discussion, I hold that the Service Rules 2019 would be applicable, which has not been adhered to at all by the respondent university. Therefore, the termination of the service of the petitioner is in total violation of the procedural requirements prescribed under the Service Rules, which expressly provide a cardinal principle of natural justice. The petitioner is entitled to an opportunity of hearing in terms of the Service Rules 2019. The procedures are clearly prescribed under Rule 19 of the Service Rule 2019, and the same has been violated with all impunity. And the petitioner, a confirmed regular employee, has been terminated illegally. The non-compliance of the mandate of Rule 90 of the Service Rules 2019 is an infirmity which goes to the root of the matter and without more wishes the action of the respondent university. In view of the discussion made herein above, I am of the considered view that the impugned termination order dated 19/4/2023 has been issued without following the principles of natural justice, which is otherwise expressly provided in the Service Rules, and without any reference to the said provision of the rules. Thus, the impugned order dated 19/4/2023 cannot be sustained. Accordingly, the impugned termination order dated 19/4/2023 issued by the Registrar of the University terminating the service of the petitioner as professor is hereby set aside and quashed. Consequently, the petitioner, namely so-and-so, be reinstated forthwith as professor in the Bhupen Hazarika School of Mass Communication with all consequential benefits. However, the respondent university is at liberty to proceed with the departmental proceeding against the petitioner strictly in terms of the Service Rules. So, my lord, this was the judgment of the Honorable Single Judge in the earlier petition. Against that, my lord, the university filed an appeal. An appellate order, your lordship, gets at page 82. Now, the Honorable Division Bench finally, my lord, say, if your lordship may kindly come to page 95. Paragraph 21 at page 95. In view of the above discussion, we have no hesitation in holding that the learned single judge has not committed any illegality in setting aside the termination order dated 19/4/2023 issued by the registrar, terminating the service of the respondent, writ petitioner as professor in so-and-so, and has rightly ordered for reinstating the respondent number 1, writ petitioner, in service forthwith on the said post with all consequential benefits. However, the appellant university can very well proceed against the respondent number 1, writ petitioner, by providing him sufficient opportunity of hearing without adhering to the procedure laid down under the service rules of 2019. My lord, the only difference, my lord, the divisions bench order made is that, my lord, Honorable Single just said that you have to proceed. If you want to proceed, you have to proceed under the service rules. But my lord, here the division bench said that you can proceed without adhering to the service rules. So, my lord, principles of natural justice has to be followed. That is the, my lord, sum and substance. Then paragraph 22. The appellant university is free to proceed against the respondent number 1, writ petitioner, but after providing sufficient opportunity of hearing to him, the appellant university is directed to provide sufficient time to the respondent number 1, writ petitioner, to furnish his explanation, reply, and after receiving the same, the proceeding initiated against the respondent number 1, writ petitioner, can be dropped if the appellant university finds the explanation reply filed by the respondent number 1, writ petitioner, satisfactory. However, in case the university decides otherwise, it shall pass a speaking and written order in that regard. So, my lord, the university has been given liberty to proceed against me, and if it accepts my explanation, then, my lord, it is one thing. If not, then, my lord, they can pass any order, but following the principles of natural justice, without following the, my lord, service rules. So that is the difference that has been made by the writ appellate order. Thereafter, my lord, after the division's order, a show cause notice was issued that your lordship finds at page 97. This is again issued by, my lord, the registrar. Of course, the registrar has changed in charge, my lord. Another person has signed. Address to the petitioner. And this, my lord, registrar, Sri Pranjit Bora, my lord, registrar in charge, he is the, my lord, same person who was also, my lord, selected in the same procedure by which, my lord, I was selected, that same advertisement. Now, my lord, this is a show cause notice. Reference, judgment and order dated so-and-so of the writ appeal. In pursuance of the judgment and order dated 22/4/2024 as passed by the division bench of the Honorable Guwahati High Court in writ appeal number 102 of 2024 and subsequent decision of the Board of Management in its 77th meeting by the resolution number such and such held on 10/6/2024, I am hereby directed to inform you to furnish your explanation reply within 30 days from the date of receipt of this communication in response to the earlier show cause notice under reference number so-and-so dated 3/4/2023, which was issued by the then registrar and duly served upon you during the relevant period. The directive is in compliance with the aforementioned judgment and order, particularly as reflected in paragraph 4, 5, 21, 22, and 23. For your ready reference, the copies of the aforementioned show cause notice, along with the report of the committee and judgment and order, have been enclosed. Now, your lordship will kindly note, my lord, here, my lord, in the third line from bottom of the first paragraph, in response to the earlier show cause notice dated 3/4/2023, So, my lord, this is a continuation of the earlier show cause notice, which your lordship finds at page 37. Because, my lord, we have to read that again, my lord. Because by that, my lord, an opinion was sought on the basis of the, my lord, the report of a committee, which, my lord, inquired the matter behind my back. So that opinion was sought. Now, so far so good. Then, my lord, the petitioner asked for some time because of his difficulty that was granted. Then, page 100, your lordship will get the order passed by the registrar in charge again. With due reference to the above and as per directive of the committee meeting held on 9 and 10 August 24, I am directed to inform you that the committee has rescheduled the hearing on 9 September 2024 from 11 a.m. onwards as per your request. I requested. The committee desires you to appear for the hearing with all the original documents, including certificate, mark sheets from HSLC to PhD, along with experience certificate, original PhD thesis, and other relevant documents which you had enclosed with your application for the post of professor. Now, my lord, what they want to do is that, my lord, they want to produce me all the documents that I had already submitted in the earlier selection, based on which, my lord, two experts has given opinion that I am eligible. Then, my lord, and my lord, interview was held, and thereafter, my lord, the board of management had a, my lord, meeting, and also, my lord, said that I am eligible. Now they want me to produce everything, my lord. I have produced. In fact, my lord, I have given the reply. I have given a copy, my lord. This is my reply. I have annexed everything to them. Now, my lord, the question here is, firstly, my lord, as I have said, there were 3 complaints, and those complaints were replied to by the university, defending that, my lord, my selection was proper, that, my lord, I am eligible. I'll produce that documents, my lord. And one of the, my lord, professors, Professor Dr. Srinath Bora, my lord, he said that I did not file the complaint. It was a manufactured one. You can deal on it to me. May I, if your lordship kindly permits me, my lord, I'll produce those documents, because, my lord, I could not file the affidavit in reply additionally. It civil design. In fact, my lord, they ought to have produced all the records. My lord, I am selecting a disciplinary proceeding against me. They ought to have produced all the documents. They have not. This is the first letter is February 5. If you also see, the Deputy Secretary has written to the Vice Chancellor, with reference to the above, I am directed to herewith a copy of the petition that is so addressed to the Honorable Chancellor KKH SOU regarding alleged gross anomalies in selection and appointment of Dr. Sri Jayanta Kumar Sharma as professor in the Center for Dr. Bhupen Hazarika School of Mass Communication, submitted by Sri Bolen Boisho, President, Hindu Yuva Chhatra Parishad, Ahom, which is self-explanatory. So, my lord, one person claiming him to be the president of a Hindu Yuva Chhatra Parishad files this complaint. Then, my lord, registrar, after that, once, my lord, your lordship will find the registrar has given a reply to that. Dated, my lord, 17 February 2022. To Sri Gitartha Boisho, Deputy Secretary, Governor of Assam, in inviting a reference to the cited, I am directed to inform the following. Dr. Jayanta Kumar Sharma was appointed as professor in Bhupen Hazarika School of Mass Communication, not in the center of so-and-so, so-and-so. The parawise information provided by the university to the petitioner under the RTI Act indicate the process followed by the university in terms of the advertisement released for the post, collection of candidates' particulars through a standard form, formation of a selection committee, preparation of interview score sheet, both individual and consolidated, submission of selection committee proceedings to Board of Management, and taking resolution by the Board of Management before issuing the appointment letter. As per records available in the office of the registrar, the selection committee considered the suitability of the candidate in terms of the requirements and performance in the interview. Based on its recommendation and subsequent approval of the Board of Management, the offer of appointment was made. Dr. Jayanta Kumar Sharma joined the university as professor of Swashenchas on 1/2/2022, and his service was confirmed after successful completion. The above assertion is made on the examination of particulars regarding the appointment of Dr. Jayanta Kumar Sharma for onward submission to the Honorable Chancellor and Governor of Assam, who will provide further details. So, my lord, the university has defended that, my lord, my selection was proper. Then, my lord, Dr. Srinath Barua, my lord, he had the last bunch of the papers, my lord. My lord, this is dated March 11, 2024. Addressed by Srinath Barua. Has your lordship got it, my lord? His Excellency the Governor of Assam, I request you kindly to permit me to place before you the following clarification in connection with the letter dated Nil addressed to your Excellency by a person named Professor S. Barua, a resident of Sanbari, so and so, regarding the irregularities in the appointment of Dr. Jayanta Kumar Sharma. I understand that an impression is created among the faculty, staff, and administration in the KKHSOU that the complaint against Dr. Jayanta Kumar Sharma was made by me in the background. Number one, that I wrote a number of letters to your Excellency during so and so on irregularities in the construction of the city campus of the university during the tenure of Dr. Hitesh Deka. That the short signature in the complaint letter by Professor S. Barua resembles my short signature which I occasionally made in official files during my tenure as founder vice chancellor of the university. I would like to clarify that I never wrote the said letter on any other letter to your Excellency on the matter of appointment of Dr. Jayanta Kumar Sharma. I have made a personal inquiry about the existence of the so-called Professor S. Barua in Housing Colony Chanmari, and I got the impression that there was no resident by the name of Professor S. Barua. So, my lord, it was a fake complaint.
Okay, we will continue to.
Submitted before your lordship. Now, my lord, the questions that fall for consideration is, my lord, whether I fulfill the eligibility criteria. On that, my lord, pursuant to their notice to show cause, we have filed this, my lord. I think this paper book is before your lordship. Oh, dear,
Yes, it is.
I'll read, my lord, a few paragraphs from this, my lord. This is, my lord, if your lordship comes, my lord, this is the reply to the show cause notice.
Mr. Chowdhury, what I understand,
My lord,
subject to your submission further on,
my lord.
what I understand is there was an advertisement, you were selected with the two outside experts constitute the matter, called for interview, you were selected. After you were selected, there were some complaints from three parties, one from a political outfit, so whatever.
Right.
And one supposed fake.
Vice Chancellor, former Vice Chancellor, who has, my lord, disowned that.
Then after the show cause was given, after the show cause, you asked to give your opinion.
Yes.
On the basis of that, you demanded some documents. The documents was given to you on 18th. And you were terminated on 19th.
My lord.
So you came to court. This court quashed the termination order. They went on 19th. Appellate court said, we are not interfering with the civil judge order, but then without following the rules, we may give the opportunity of hearing.
Yes, madam.
On the basis of that, this committee called you with to come along with all your necessary documents. So what I understand is that they are trying to give you a hearing to this committee.
Yes. True.
So I don't think you should be agreed.
My lord, I'll satisfy your worship on that. The issue here is, my lord, the show cause notice was issued where, my lord, behind my back, there was a, my lord, finding that I do not fulfill the eligibility criteria. My case in this reputation is that, my lord, the university followed all the steps necessary following the UGC guidelines. And after the, my lord, taking expert opinion from some outside experts who held me to be eligible, you had taken me, taken my interview by a board constituted. Thereafter, the appointment and everything followed. Now the question that comes, my lord, the inquiry committee said that I do not have the eligibility.
And that committee inquiry, we have not gone through that.
Yes, my lord. That I'll take your lordship to that. The question that falls for consideration is that, my lord, the only thing the university can do is, my lord, see whether I fulfill the conditions, eligibility conditions or not. What they are proposing to do now is to hold a fresh selection of the, my lord, for the post, which I have already undergone and I have qualified. My lord, let them show, my lord, this is, my lord, my ultimate submission. Let them show any, my lord, procedure which has not been, my lord, followed, which is laid down under the rules. Because in the name of holding an inquiry now by a committee, I do not say, my lord, it has to be a disciplinary authority, presenting officer. I do not say that. Okay, a hearing is sought to be given by a committee. What is that committee? I'll come to that, my lord. Now, the only thing you can do is that, my lord, whether my selection, earlier selection was proper or not. If they can show, my lord, one deviation from the procedure of selection laid down in their, my lord, first statute and the UGC guidelines, then, my lord, your lordship will not suit me. Now the question is, my lord, in the name of giving a hearing, you cannot hold a fresh selection. What they are seeking to do, they want all the, my lord, documents that I had submitted in my earlier selection, including the thesis. And, my lord, I had gone through and, my lord, successfully come through a selection, which was, my lord, done by their own committee, which was defended by them in subsequent communications, my lord, complaints against me. And, my lord, that process of subjective selection, subjective, my lord, satisfaction regarding my eligibility now cannot be assessed by another committee with a, my lord, fresh substitute, my lord, the subjective satisfaction. This is the, my lord, crux of the matter. I have, my lord, gone through a selection process. You have done it. If there is anything wrong in the, my lord, that my lord, procedure, any deviation of the guidelines laid down, then, my lord, I am out of the court. But in the name of holding an inquiry, you cannot have a, my lord, fresh selection committee. And what is that committee? Your lordship, one of the board of members, my lord, he gives a, I'll take your lordship to that. He gives a report against me. Then, my lord, in the board of meeting, he sits there and approves that committee, my lord, the report against me. And on that, my lord, they are holding an inquiry and that particular person will be there in the, my lord, this committee before which I'll appear. Everything is predetermined, my lord, to oust me from the university. They cannot do that, my lord. They may have a committee. I do not, my lord, dispute that. The division bench order, my lord, I do not dispute. I abide by that. All the, my lord, the division bench said is that you give him an opportunity. Opportunity for what? The original show cause notice. Now, in the name of holding a, my lord, the committee and the inquiry, my lord, what they are trying to do is that, my lord, they are trying to go to for my selection again. One person cannot be selected twice. One person cannot be made to undergo a selection process twice. That is what they are trying to do. And, my lord, the report that has been given by one member, that has been, my lord, placed before a committee, a board of meeting. In the board of meeting, my lord, that person is also there who approves it. And that person is there in the, my lord, the committee before whom I'll appear. He is a member of the board of management, and thereafter he will approve it. Will your lordship, my lord, allow that? That is what I am trying to, my lord, to satisfy your lordship on. So far as my qualification is concerned, my lord, yes. So far as my lord, that particular clause is concerned, A and B, though two alternatives, A is for academicians, I do not fulfill that, my lord. That's an admitted fact. That is what I wanted to show.
You come
That
under B.
I come under B. And under B, my lord, I have been said that I am eligible by two experts who are not, my lord, known to me, who are from some other university. You have selected them. Subsequently, my lord, they want to say that now that committee gave a wrong report, therefore we are removing them from the university. So you had selected them. They have, my lord, given report in my favor, holding that I am eligible. And they have not, my lord, they have gone only to the extent of eligibility, not suitability. Suitability has been determined by the university, your committee. And that suitability, my lord, pursuant to which I was appointed and regularized, against the complaint, my lord, the university itself, my lord, defends that everything was in order. Then all on a sudden, my lord, something happens because of the complaints who are not associated with the, my lord, the affairs of the university, except, my lord, Dr. Srinath Bora, who says, my lord, I do not own this. You are holding it, you are going to subject me to a fresh selection. That cannot be done, my lord. That's why, my lord, I'll show, my lord, what is the constitution of the committee and who are the members of the committee, my lord, who had given report against me. And, my lord, he approved it as a member of the board of management. Now he is in the committee where I'll appear. And then, my lord, he'll be there in the board of management where, my lord, that the committee will give the report. And obviously, my lord, it will be approved. So, my lord, the only thing, my lord, pursuant to the order of this honorable court by the division bench, they can do is that, my lord, whether I fulfill the eligibility condition or not, that is the only thing they can, my lord, scrutinize. Not beyond that, they cannot hold a, my lord, fresh selection in the name of, my lord, holding an inquiry. This is my case, my lord. If, my lord, one deviation from the, my lord, procedures laid down and the eligibility conditions is, my lord, satisfied, then, my lord, your lordship will not suit me, my lord, today itself. But then, my lord, they have already, my lord, earlier your lordship will see how they are predetermined. Give me the copies on 18th, you terminate me on 19th. Now you are holding, my lord, giving it to a committee which will, my lord, assess my suitability. And why do you need the thesis? Now they, my lord, they can make a subjective assessment that, oh, your thesis was not good, so we will not give marks on the thesis. Can they do that, my lord? So that will be, my lord, holding a fresh selection for the post where, my lord, I was appointed pursuant to a regular process of selection without any deviation of the UGC guidelines and the, my lord, statutes of the university. That is what I am trying to satisfy your lordship on, my lord. That's why, my lord, your lordship will give me, my lord, 15 minutes maximum. So that is my case, my lord. Because, my lord, earlier background was necessary to show that, my lord, they are, my lord, hell bent upon to oust me from the university. What happens to those persons, my lord? I have written in the show cause notice. Not only me, my lord, you advertised for 4 posts. Same process of selection, same outside experts, I mean, different subjects. On that basis, they were selected. One of them is holding the post of registrar now. Why do you single out me? Why don't you take action against them? Both of them are professors. One is holding a post of registrar in charge. So malafide is, my lord, writ large in, my lord, every step. And I, my lord, your lordship will see, my lord, the qualification laid down in B, my lord, I fulfill everything, my lord. Thereafter, the committee you had constituted, that has with us, they had the subjective satisfaction of selecting me. And now you can do it again. Can a person, an appointed person can be, my lord, made to face a selection once more? That is what you are doing now. I'm aggrieved by that, my lord. That's why, my lord, I wanted to read some paragraphs in my show cause notice, my lord, where I have admitted I do not have the eligibility condition laid down in A, but I fulfill the conditions in B. And I have also pointed out, my lord, those persons who have been selected in the same process, they are, my lord, happily working in the university. You have not taken any action against them. I have been singled out. And that, my lord, the person, my lord, who has written a report against me is a, my lord, member of the executive, my lord, board of management. He approves that. He is a member of the selection committee. Again, my lord, I mean, that committee which will, my lord, assess my eligibility again. And that will be submitted before the, my lord, committee, board of management, where he is a member. Your Lordship, may kindly, my lord, bear with me for some time. That is the position, my lord, I want to satisfy your Lordship on. Your Lordship may come to page 2, my lord. These are my preliminary submissions. That, sir, it is apparent that the inquiry against my appointment as professor in Bhupen Hazarika School of Mass Communication was necessitated by a complaint by the Chancellor of Krishnakanda Hendrik State Open University by Professor S. Borough of Housing Colony number so-and-so, forwarded by University Grants Commission, which alleged that I had no qualification to be appointed as professor and hence action should be taken against me. The committee had noted in paragraph 2 of the inquiry report that 2 other petitions were earlier forwarded by the Office of the Chancellor of the University and Honorable Governor of Assam in February so-and-so, which has alleged gross anomalies and irregularities in my selection and appointment as professor in Bhupen Hazarika so-and-so. The contents of the language of the petitions are almost similar that I have placed here before your Lordship and also reiterated by Professor Borua in her letter. B. That, sir, I'm not reading entire, some paragraphs I'll read. That, sir, the main allegation raised by the 2 petitions and the letter from Professor S. Borua of Housing Colony Chanmari were that I had only 1 publication against the requirement for 10 research publication is peer-reviewed or UGC listed journals at the time of my appointment. B. I was never actively engaged in research work and had not submitted any evidence of successfully guiding doctoral candidates at the time of my appointment. C. I had not submitted any valid teaching experience evidence as I was a regular employee of the Indian Railways from 1997 to 2021. I could not submit any documentary evidence to prove that I was an outstanding professional, nor I could show that I belong to the industry. E. No proof of my significant contribution to the knowledge in the concerned allied relevant discipline was submitted by me along with my application. So these are the allegations against me, my lord. In those complaints, C, your Lordship will kindly read. That, sir, reading of the inquiry report makes it clear that the above allegations were taken as reference points by the inquiry committee. It is pertinent to note that the conditions mentioned in A, B, and C of the above allegations are relevant to teachers recruited in clause 4.13a of the UGC regulation 2018, appended as Annexure 7 of the inquiry report, and conditions mentioned in D and E above allegations are relevant to the teachers recruited under clause 4.13b of the regulation 2018. These 2 clauses of UGC regulations are mutually exclusive, and the inquiry report has dealt about the said regulation in paragraph 6, 10, 10, 11, and 12. That's the report of the 2 outside subject experts screening the applications received for appointment to the post of professor of the clearly states that I was recommended for invitation for personal interview by a selection committee under clause 4.13b of the UGC regulation 2018. This is recorded by the inquiry committee report under para 19 and 28 appended as Annexure 9 of the inquiry report. It is pertinent to note that these 2 outside experts were chosen by the Board of Management in its 59 meeting held on 19/10/2020 as mandated by para B of chapter 6 of the first statute of the KK Hendrik University and as recorded in the inquiry report at paragraph 18 as appended as Annexure 10 of the inquiry report. Needless to say, the said 2 outside experts were chosen by the Board of Management long before I was associated with the university in any capacity, and I had merely applied for the post of professor pursuant to the advertisement thereof. Then E, in continuation above, I am furnishing my qualification thereto, making me eligible for selection and appointment under clause 4.13b of the regulation 2018 on the decision of the committee as elaborated below. Now, your Lordship may skip and come to my lord, page 7. Because he is justifying, my lord, his eligibility. That, sir, before joining the Northeast Frontier Railway, I had worked as a sub-editor of the English daily newspaper published from Guwahati named The Sentinel from 94 to 97, 3 years, 6 months, as evidenced from page 16 of the documents, has accepted to be having its in his position at the time of screening of my application for appointment to the post of professor, mass communication, so and so, page 16 of the Annexure A. This is an industry experience as stipulated in clause 4.1.3.b, my lord, that because one of the allegation is that I do not have the, my lord, the industry experience. Then 9, I had joined NF Railway as Senior Publicity Inspector on 1/7/1997 and was promoted as Public Relations Officer Group B of Indian Railways in 2001, as stated by my controlling officer in NF Railway, as evident from page 17 of the documents of SPIO. SPIO, University has accepted to be having possession of KKH SOU at the time of screening my application for appointment to the post of Professor, Mass Communication, para so and so, so and so. As Public Relations Officer, I had proved my competence in crisis communication, media handling, writing prowess, knowledge of printing technology, and use of information technology. I continued to work in NF Railway as PRO till 13/1/2021, when I was promoted as Senior Public Relations Officer. Therefore, I have more than 23 years of industry experience and fulfill the minimum eligibility as stipulated in clause 4.1.3b of the UGC Regulation 2018. Now, my lord, your lordship may kindly come to the next page, clause 12. That, sir, owing to my domain knowledge and industry experience, I had been invited by the Guwahati University at different points of time since 2008 to render my service as domain expert, to teach postgraduate students, to evaluate answer scripts of postgraduate students, to set question papers for postgraduate students, to assist preparation of syllabi for postgraduate students, courses, to evaluate postgraduate dissertation and conduct viva voce, to advise the Department of Communication and Journalism of Guwahati University, so and so. Then 13, my lord. That's, sir, page 111 of the documents of the SPIO of the university has accepted to be having its possession at the time of screening my application for appointment to the post of professor. May kindly be perused. It contains a statement from Sri Samudragupta Kashyap, who has later become Information Commissioner of the my lord, Assam Information Commission, and currently serving as Vice Chancellor of Nagaland University, vouching for my prominence in the public relations professional in the Northeast. Then 14, my lord, another, my lord, eligibility. Now, my lord, your lordship may kindly come to page 10, clause 15. This is important, my lord.
My lord, can I just come in, my lord, with lordship's kind permission? Now, what your lordship is deciding, not the merit of the case, whether he is eligible. My learned friend is making an argument as if he is for the first time arguing his case. Why I'm saying so, my lord? He is not aggrieved by the division benchman order anymore, because he files a review has been rejected, SLP has not been filed. Now, what because I'm saying so, my lord, because my learned friend is making argument on merit. Whose case is it? The appellant university is free to proceed against the respondent writ petitioner, but after providing sufficient opportunity of hearing to him. So division bench has given the liberty to the university to proceed in the matter. By giving earlier notice was not given, therefore now notice is to be given. Now he has to explain his case before the authority. Now where is the scope of making an argument that he fulfills all the eligibility, this and that you satisfy the authority? Well, with all sense of responsibility, I'm making this submission. Why my learned friends should take the valuable time of this honorable court by embarking upon an area which is not even called upon to do so? And he has been given. However, in case the university decides otherwise, itself passes speaking and reason order in that regard. Now, his case is, my lord, he is challenging that notice. Now, why that notice is bad? You make your submission. Why are you making your argument on merits of the case? That the authority will decide. Or you have not filed SLP against this order. This order has attained finality. Therefore, I am saying, my lord, why should your lordships even go to that aspect? That's my humble submission, my lord, for your lordship's consideration.
Now, my lord, as I have already submitted, my lord, my grievance is that this committee you have constituted cannot go into the, my lord, my eligibility conditions. So that's why, my lord, I am reading this. Your lordship will kindly come to paragraph, page 10, paragraph 15. This is very crucial. That's sir, page 118 of the documents SPAO KK has accepted to be having in its possession at the time of screening of my application for appointment to the post of professor in mass communication in Bhubaneswar Institute. Page 118 of the Annexure A mentioned in para 4 of the submission is a notification issued by with the approval of the Vice Chancellor, Guwahati University, received on 22/7/2017, appointing me as a member of the Committee of Course and Syllabus of PG Department of the Communication and Journalism. Now, in the light of the observation in paragraph 27 and 28 of the Inquiry Committee report, it is very pertinent to note that from August 2003 to August 2019, the Vice Chancellor of Guwahati University was Mridul Hazarika, who is also one of the authors of the Instant Inquiry Committee report. Now, my lord, Sri Hazarika, who was the Chancellor of Guwahati University, who has utilized my service, now, my lord, he has given a report. And that your lordship will find at, my lord, page 40 of the writ petition. Your lordship will read that because, my lord, I am trying to satisfy your lordship on the point that, my lord, this committee has been constituted with a preconceived mind where a person, my lord, who has given report against me is a member of the selection of the committee. He is a member of the, my lord, the board of management, and he is also a member of the, my lord, the committee before whom I am supposed to appear. Now, your lordship will kindly come to page 40 of the writ petition. The report of the committee on examination of the selection procedure and eligibility of Professor Jayanta Kumar Sharma. Now, this report, if your lordship, my lord, reads paragraph 2. After joining the university, various queries, RTIs regarding appointment of Jayanta Kumar Sharma have been received. Deputy Secretary to the Governor of Assam had forwarded a copy of the petition that is so-and-so addressed to the Honorable Chancellor, which was submitted by Sri Bolen Boisho, President Hindu Yuva Chhatra Parishad Assam, regarding alleged gross anomalies in selection and appointment of Sri Jayanta Kumar Sharma as professor. Now, that is a, my lord, complaint of a political outfit. Then Additional Secretary to the Government of Assam, Chancellor's Secretariat had forwarded a copy of the petition, reference so-and-so addressed to the Honorable Chancellor, submitted by Professor R. Media of Khanapara. This was, my lord, defended by them, the same university, my lord, earlier. Then 3, Deputy Secretary, UGC, had also enclosed copies of the letter received from Deputy Secretary, Ministry of Education, forwarding a complaint of Professor S. Borua. That, my lord, I have already satisfied your lordship, my lord. Professor S. Borua has, my lord, denied his, my lord, his involvement. Now, paragraph 4 is important. Accordingly, a committee has been constituted to examine the selection procedure of Professor Jayanta Kumar Sharma as professor by office order number such and such with the following members. Dr. Mridul Hazarika, Honorable Member, Board of Members, Board of Management. Professor Muniba Kumar, Munish Kumar, Honorable Member, Board of Management. Director, ACD, IGNO. Now, my lord, these two persons are the, my lord, members of the board. And, my lord, this Mridul Hazarika was the Vice Chancellor of Guwahati University, my lord, who utilized my service earlier as a, my lord, distinguished person. Then, your lordship may kindly come to page 48, conclusions. Your lordship, notice, my lord, this is the report of the, my lord, committee. Conclusion, page 48. Has your lordship got it, my lord? Based on the above observations, the committee is of the opinion that Dr. Jayanta Kumar Sharma did not fulfill the eligibility conditions for appointment to the post of professor at the time of selection. Committee also observed that there were deviations in the selection procedure and lacked transparency, which requires enough checks and balances so that such instances do not occasion in future. The committee is thankful to so and so, so and so. This is signed by my lord, Dr. Midul Hazarika. And on the other side, there is a my lord, Professor Munish Kumar, who did not sign it. So, my lord, this gentleman, Mr. Hazarika, has given a report against me in the name of the committee, although the other member of the committee, my lord, did not sign it. Then your lordship may kindly come to the of this, my lord, once your lordship may kindly come to page 19. Page 19, my lord. Paragraph 33. That said, the inquiry committee's observation in para 15 of the inquiry report mainly pertains to selection of teachers under clause 4.1.3a of the UGC regulation. However, in the last part of the said para, committee observed that while clause 5 of clause 6 of the UGC regulation 2018, UGC has notified that in case of selection of faculty members who are from outside the academic field and are considered under clause 4.13b of these regulations, the university's statutory board must lay down clear and transparent criteria and procedures so that only outstanding professionals who can contribute substantially to the university knowledge system are selected. Then your lordship may kindly skip and come to next page, subpara, first subpara. What the registrar failed to state and the committee has also failed to note was that same format was used for screening all the applications received against advertisement number such and such for recruitment of professors in different schools of the university. The format was apparently developed in compliance to the clause 5 of clause 6 of the UGC regulation 2018. I am appending the assessment report for screening of the applications and summary of the assessment report for the two posts of Professor Suryakanto Bhuya, School, and Padmanath Gohai Borua, Humanities. Why these two persons are, my lord? These two professors recruited through the same procedure where Dr. Pranjit Bora and Joydeep Borua, who are still in the employment of the university as the registrar in charge and director, Surya Kumar Bhuya, School of Social Sciences. Same process, my lord. Now they say, my lord, the process is wrong. If the process is wrong, then, my lord, why don't you proceed against them also? Why do you pick me up? Because, my lord, as your lordship has, my lord, read in the conclusions, my lord, the eligibility conditions, page 48, my lord, eligibility conditions are to be assessed. Experts have held, experts appointed by them have held that, my lord, I am eligible. And now you constitute a committee. I'll show the, my lord, committee constitution where, my lord, other experts are there. Your lordship will kindly come to that, my lord, at page 103 of the read petition. This is the committee constituted, my lord, before which I am supposed to appear, which will give me a, my lord, reasonable opportunity of hearing. This is for information of all concerned that as per resolution number such and such, so the 77th meeting of the Board of Management held on 10/6/2024, the following committee has been constituted to examine the explanations to be submitted by Professor Jayanta Kumar Sharma in response to the show cause notice issued to him. Number one, he is a professor, he is a member of the board of management. Number two, Professor L.K. Nath, Board of Management. Number three, Professor Prahlad Kumar Joshi, Honorable Member, Board of Management. One UGC official, not named. One subject expert, not named. Now, what they're trying to do is, my lord, as I have already stated, my lord, at the cost of repetition, I am saying, my lord, this report will be submitted before the Board of Management, my lord, the Board of Management, and, my lord, the reports have been, my lord, given by the member of the board of management earlier against me. And my lord, why don't you name them and why do you need an my lord subject matter expert? Subjective satisfaction was there, my lord, already. Only thing, my lord, you need to do is, my lord, whether I fulfill the eligibility criteria or not. Can you hold this election afresh? This is in effect, my lord, holding a fresh election. That is where my grievance is. In the name of, my lord, holding an inquiry, giving me an opportunity to show cause, you cannot, my lord, hold a fresh election. And, my lord, only thing, my lord, they need to establish is that, my lord, there has been violation in the earlier procedure of selection. If, my lord, there is any violation of any, my lord, requirement, or, my lord, I do not fulfill any eligibility in, my lord, clause B, and, my lord, the subjective satisfaction of the, my lord, earlier selection committee, that cannot be changed by my lord, next committee, unless, my lord, there is some violation. Where is that violation? And how can, my lord, this committee assess me? This committee cannot assess me because, my lord, the board of management, members of the board of management has already given a report against me. Whatever this committee decides will be placed before that committee, board of management, and board of management will definitely, my lord, will decide against me. They cannot go, my lord, it will not be, my lord, appeal from Caesar to Caesar. It will be an appeal from Caesar to Caesar, Caesar's wife, not, my lord, Caesar. This is my precise case, my lord. My precise case is that I'm accepting the, my lord, division bench order. Division bench said that you do not need to follow the service rules, but you have to give me a reasonable opportunity. That opportunity has to be fair. This is, my lord, absolutely unfair. Therefore, my lord, this constitutional committee, I am challenging that. Your lordship will see my prayer. What is my prayer in the writ petition? I had to take your lordship to the, my lord, the qualification that I do not possess and I possess because of the fact that, my lord, that is the only aspect you can go into in a proceeding against me. Paragraph 1, page, my lord, 24. A writ in the nature of certiorari should not be issued to the respondent authorities to set aside and quash the committee constituted by resolution number so and so. Then, my lord, paragraph 2. A writ in the nature of certiorari should not be issued to the respondent authorities to set aside and quash the later dated 21/8/2024, seeking to revisit the credentials of the petition. My lord, after a person, my lord, fulfills all the eligibility, one committee may have the satisfaction that, yes, you are eligible and you are suitable. Another committee may say that you are eligible, but you are not suitable. This is a subjective satisfaction, man. How can you do it again? Cannot do it again. One person cannot be selected twice. Go through the, my lord, undergo the process of selection twice. That is what you are trying to do. That's why, my lord, the committee constituted is, my lord, absolutely arbitrary, illegal, unfair, unjust. And, my lord, the result that is come out, that is, my lord, obvious. That's why, my lord, I reiterate, at the cost of repetition, I say, my lord, that let them show one deviation of the EGC guidelines or their, my lord, the first statute or whatever statute and regulations do have, which, my lord, has been violated in my selection process. And therefore, you cannot revisit the same, my lord, selection once again. Only thing you can go is to, my lord, make an assessment whether I was eligible or not. Suitability, you cannot decide. Eligibility, yes. But eligibility, as per, my lord, clause B, and I have said, and I fulfill that. That is why, my lord, I have read those, my lord, the paragraphs, and I was not taking the time of the court, honorable court, my lord, unnecessarily. Because, my lord, the malafide on the part of the authorities is apparent and clear, and this is a, my lord, very unfair procedure they are following. This is my submission, my lord. Subject to what my learned friend may say, I'll give a reply.
My lord, after hearing my learned friend, the impression I am getting is if an administrative authority takes a decision once, then that decision is not open to re-examine that. If that is a facet of administrative law, then it's a new thing I've learned today. Because a decision taken, even if it is wrong, even if it is erroneous, it has to stand. Selection once made, may come what may, it has to withstand. Well, these are all new jurisprudence which you are learning below. Now, what is this case? A person who was working as a PR of NF Railway was appointed by a person who has been dismissed from service. The Vice Chancellor, that Kondorpo Das was instrumental in appointing
My
the
lord, I'll
petitioner.
just take a while, my lord. This is not in the pleading. Let him not, my lord, argue anything beyond pleading, my lord.
My lord, I'm reiterating, he was appointed during the time when Kondorpo Das was the Vice Chancellor and he has been dismissed for so many wrongdoings.
This is not in the pleading.
Yes.
This is not in the pleading.
This is what I'm reiterating. Now, Lordship, now what is the case all about? Now, my learned friend has repeatedly made one submission. If one infirmity can be shown, then he should be non-suited. Yes, I'm going to that. Lord, we kindly have this regulation, UGC regulation. He is repeatedly making this argument. Show one infirmity. Yes, I'm coming to that first. Now, please come to my lord, page 60. Page 60 on top. I think third pages may not tally. Professor. Has your lordship got it, Miller? Towards the bottom. Roman 3, professor. Eligibility A or B. My lord, A relates to a person who is from academic side. Am I clear? So he is not from academic side. Now he is from, my lord, the B stream. Because he was not a professor or an assistant professor or an associate professor. He was a public relation officer of NF Railway. Now kindly see, Miller. An outstanding professional having a PhD degree in relevant allied applied discipline from any academic institution not included in A above / industry, who has made significant contribution to the knowledge in the concerned allied relevant discipline, supported by documentary evidence, provided she has 10 years experience. If you do not belong to the academic stream, even then also you can be selected for the post of professor, in which case you must have a PhD degree in the relevant field and you must have made significant contribution to the knowledge in the concerned allied discipline, and in support of that, you are to bring documentary evidence. Now, my learned friend has referred to that committee's report where they found infirmities here. So this he was not fulfilling, number one. And most important is, my lord, please come to page number 76. Now,
of the writ petition.
no, my lord, this compilation. Yes.
This thick one.
No, my lord, the one I have given.
This one.
Yes, yes. Please come to selection procedure 60. Selection procedure 6, page 75. On top is the page, right hand side.
Yes.
Selection procedure, please come to the next page, Roman 5. Did my learned friend advance any argument on this point? Roman 5. In case of selection of faculty member who are from outside the academic field and are considered under clause 4.1, etc., etc., etc. of this regulation, the university's statutory body must lay down clear and transparent criteria and procedure so that only outstanding professional who can contribute substantially to the university knowledge system are selected. Let my learned friend place this criteria of selection. So in the absence of any criteria, subjective satisfaction has gone in. Now, how to assess him? That he has made substantial contribution toward development of the subject. For example, my lord, if you have submitted so-and-so article, then you will get X mark. If you have done so-and-so, then you will get X mark. Where is that? Lordship must have noticed from the inquiry report, these are the 2 points. One, he could not produce any material in support of his claim that he has made substantial contribution to the subject. And secondly, my lord, these criteria are missing. In the absence of the criteria, he could be selected. This is the, meat of the matter, my lord. These criteria were never framed by the university before selecting him. In the absence of the criteria being, enumerated, arbitrariness, nepotism, favoritism, everything has come in the way. So we are helpless. One Mr. Jayanta Kumar Sharma will get an employment illegally and university is helpless. Is this the argument? This is the infirmity, my lord. My learned friend was repeatedly arguing. Let them show one infirmity. Let him answer this, 5. That this was done and the selection was done accordingly. Now please come to that inquiry report, my lord, for a moment. Though I will not delve in the inquiry report. Read petition of December. 40. Yes. Please come to page 43, my lord. Please come to page 43, screening of applications, para 17. The UGC, by its regulation of 2018, had specified the methodology for the university and college teachers for calculating academic research score. It has laid emphasis that assessment must be based on evidence produced by the teacher and a copy of the publication, project sanction, etc., letter, utilization, etc., and acknowledgement for the patent filing approval letter, student PhD award letter, etc. Therefore, it was necessary that the applications were screened based on publication and other documentary evidence strictly on the criteria notified by the UGC by table 2 of the regulation, and also university in its advertisement. However, in the instant case, the same has not been followed, as is evident from the records available with the university. So what more is required, Miller? The committee observed that assessment reports from the 2 subject experts formed the basis of inviting Jayanta Kumar Sharma and Dipendra Kumar Majumdar for the selection nominee meeting, committee meeting. The assessment screening reports were received from Professor so-and-so, deemed to be university, and Professor Krishna Anand, Department of History, Sikkim University. In fact, only one of the 2 experts was from the field of mass communication. However, we are not able to offer our comments since two are part of the panel of experts of Bhupen Hazarika School of so-and-so. The assessment report of the experts were based on a format. However, it is not clear who had designed the format, since the registrar or the recruitment cell is not aware of development that such a format. What is striking is that both the experts had mentioned that the 2 candidates who and not meaning the However, we are not able to offer our comments since the 2 are parts of the panel of experts. Sorry, para 19. The assessment report of the experts were based on a format. However, it is not clear who had designed the format, since the registrar or the recruitment cell is not aware of the developing such a format. What is striking is that both the experts had mentioned that the 2 candidates who were initially not meeting the eligibility conditions are eligible to be considered for the post of professor under so-and-so. It raises suspicion on the overall process of screening. Nowhere in the assessment report, screening report has been mentioned that assessment screening has been done after going through the application along with the research publication and the documents. Kindly refer to B now, my lord, that in support of the fact that he had made substantial contribution, some materials must be there. Those were not there. And these two experts have said he is eligible. So we have to accept it. Then the very basis on which assessment report is based is questionable. In fact, Dr. Jayanta Kumar Sharma has not enclosed sufficient document to prove that he was teaching or having industry experience, since he had submitted only one research publication and one paper presented in a conference which are not adequate to evaluate the one's quality of research, range of research quality and publication, that from the criteria designed by the university in the format assessment. Two experts have awarded him either excellent or very good in their parameter, raises question, a serious question. Nothing was there, only one paper was there. Now, my lord will kindly come to para 28, page 47. Para 28. My learned friend was repeatedly saying, what is the infirmity? Now, this is the pointed infirmity. While going through overall process of selection as well as credentials mentioned in this application, the committee had also tried to explore if appointment of Jayanta Kumar Sharma was considered or could be considered in clause 44(1)(b)(3)(2)(b) of the UGC regulation. The UGC under this clause had specified an outstanding professional. Now I will not reading it, Miller. In the instant case, this criteria has not been considered in the selection of Dr. Jayanta Kumar Sharma by the selection committee or by the university, as is evident from the minutes of the selection committee and records of the university. However, the two experts in their assessment report had mentioned for considering the application under this criteria. Although assessment report is itself faulty and not based on the verifiable criteria of UGC, the committee observes that the application of Jayanta Kumar Sharma could not have been and cannot be considered under this criteria, since expert having PhD. There is nothing on record to prove that he was an outstanding professional who had made substantial contribution to the knowledge in the concerned allied receiving discipline. He had only one research paper to his credit, and there is no documentary evidence to support that he made such a significant contribution to the knowledge in the area of mass communication. He was working as a PRO. As a PRO, his job profile in the railway was different than the job profile of a researcher working in a research institute or a professional developing policy document or bringing new inventions or adding to the knowledge of the discipline. There is no evidence to prove that he had obtained any research project or developed any new teaching, learning pedagogy, or produced any pure policy document, etc., so as to consider as outstanding professional. Moreover, UGC, now this is important. Moreover, UGC by clause 6.5 as mentioned, the criteria for selection of faculty member on 4.13b, according to which statutory authority of the university must lay down clear and transparent criteria and procedure so that only outstanding professionals who can contribute substantially to the university knowledge system are selected. In the instant case, no such criteria or procedure has been laid down by the university, and accordingly, neither it could select Jayanta Kumar Sharma, nor the criteria, nor it was selected him under this criteria. So what more is required, my lord? That is why, my lord, all these arguments were made before division bench. Division bench says nothing doing. All right, you were not heard, now you will be heard. Now, my lord will kindly come to the division bench order. Number one, he has not made any contribution. Number two, there was no selection criteria. Therefore, now the authority has taken a view, subject to further orders, that his selection was not proper. Now, my lord will kindly come to the division bench order at page 95. Now, this order has attained finality. In para 22, in view of the above discussion, we have no hesitation in holding that learned single judge has not committed any illegality in setting aside the termination order issued by the registrar, terminating the services of the respondent petitioner as professor of so-and-so and has rightly ordered for reinstating the petitioner, forthwith on the said post with all consequences. However, Appellant University can very well proceed against the respondent on petitioner by providing him sufficient opportunity of hearing without adhering to the procedure to the laid down under the service rule. But the learned single judge was of the view that since he is already appointed, now that means you are taking a disciplinary action, therefore comply with Article 311. That is which has been not negated by the division bench. The appellant university is free to proceed against the respondent writ petitioner, but after providing opportunity of hearing to him. The appellant university is directed to provide sufficient time to the respondent writ petitioner to furnish his explanation, reply, and after his same, the proceeding initiated against the respondent writ petitioner can be dropped if the appellant university finds explanation reply filed by the respondent number 1 petitioner satisfactory. However, in case the university decides otherwise, it shall pass a speaking order, a reasoned order. Well, this order of the division bench carries some meaning. It cannot be understood in the manner as my learned friend would like to suggest. The division bench has given clear mandate to the university, issue a show cause notice and hearing, then take a final call. If you accept his contention is well and good. If you don't accept his contention, then give a speaking order. Now, pursuant to this, my lord, please come to page 97. Oh. 11/6/24. In pursuance to the judgment and order dated as passed by the division bench of the High Court and subsequent decision of the Board of Management in its 77 meeting, I hereby direct you to inform you to furnish your explanation within 30 days from the date of receipt of this communication in response to the earlier show cause notice dated so and so, which was issued by the then registrar and duly served upon you during the relevant period of time. Earlier, because, my lord, there was no opportunity of hearing was given. Therefore, division bench say, if you want to take any action, give him a show cause notice. Now, after this, my lord, he submitted his reply. That your lordships will get at page number 102. Oh, no, sorry, 100. Page 100. This is another communication by university. Now, this is he has challenged this also, my lord. With due reference to the above, and as per directive of the committee meeting held on 9th and 10th August 24, I am directed to inform you that the committee has rescheduled the hearing on 9th of September 2024 at 11 AM onwards as per your request dated 7/8/24. The committee desires you to appear for the hearing with all original documents, including certificates, marksheets from HSLC to PhD, along with experience certificate, original PhD. Now he is saying that he is so-and-so, he has got all the experience. Therefore, please come with this. Satisfy us that you have, will retain you. If you come so, we'll say, no, we cannot do. Where is the question of prejudice? Where is the question of bias at this stage? Now he has submitted his reply. Kindly see, my lord, the second reference. Your explanatory reply dated 10/7/24 to the communication dated 11/6/24. My lord, let me make one very harsh submission. Now it is said, he who seeks equity, he must come with clean hands. And he must also make, my lord, candid disclosure of the facts, which is the statement in the writ petition that he has submitted his reply and what prompted him to file the writ petition. Where is that? What he has done, my lord, he has not only submitted his explanation, he has also filed a petition which he has not annexed. Certainly he will not annex. This is his conduct all throughout. Please take our IA, my lord. Page number 42. This is where, my lord, that candid disclosure of fact is something which is a sine qua non. Page 42 of the my IA. page 42. Committee যে বানাবো পরে এটা। With due respect, I would like to bring to your notice that my only child Kabir Sharma has a psychological breakdown last night following suicide by one of the students in USTM, etc., etc. But for Sapera, in view of above, it will not be possible for me to attend the hearing before the committee as mentioned in your letter referred to above. I therefore request you to kindly grant me one last chance of appearing before the committee on the date convenient for you after 15/8/24 and online. Like, is it fair on his part now to come to this High Court and my lord make all these sweeping allegations? What is your conduct? You have filed your reply, you have submitted to the jurisdiction. When the date of hearing is fixed, you said my son is unwell. University being magnanimous, my lord issued that order or letter at page 97. Please appearing on 8th of September. Then he comes to this court and still till he obtains an order. This is his conduct. So these are the factual parts. My learned friend's argument that he was once selected by a committee, therefore it cannot be subject matter of re-verification again, is an aspect which your lordship will has to reject it. There's no option because division bench has given us the liberty. Number one, my articulation. Number two, where from we derive this authority? Apart from the division bench order, my lord, our statute gives us the power. Yeah. My lord, the first statute starts at page 46. Page 46. In exercise of the power conferred by section 22(1) of the so-and-so university, the government hereby makes the following first statute. Now, my lord, will kindly come to page 50. Apart from the order of the High Court, my lord, the statute itself empowers, my lord. It's a power of the Board of Management to appoint such committee, either standing or temporary, as board may consider necessary, and determine the terms of reference thereof within the limitation of the Act. So it's not that, my lord, we are acting in thin air. We are supported by statutory backing. Now, my lord.
It is statute 1.
Yes, statute, my lord. It will be. I think statute. I can number over here. It will give a one. In fact, if your lordship kindly comes to page 48, Board of Management 1. So 1 Roman 6J. 1 Roman 6J. Under chapter 2 of the first statute. Now, my lord, the issue that arises is, now my learned friend is saying so-and-so is on the Board of Management, so-and-so I'll be with. My lord, a trial magistrate frame charges. Sometimes what we do, my lord, when after framing of the charge, we assail in the revision or appeal, my lord. Sometimes it may be allowed, sometimes it may be refused. The same trial magistrate who frames charge, he conducts the trial. So therefore, we'll go and say, oh, you have framed charge, you cannot take trial. My lord, what meaning we give to doctrine of necessity? End of the day, my lord, we are making an argument in an administrative forum, law forum. If such views are to be taken, then my lord, there will be chaos in the administration. Oh, you can commit everything, others cannot. But the same magistrate, he framed charge, we assail, we do not get relief. We subject ourselves to the trial before the same magistrate. So we'll come up with an application. You cannot take up the trial because you have framed charge. I'll come to the High Court, as my learned friend has done here. Will your lordships give deference to that? Certainly, your lordships will not give judicial imprimatur to such a stand. My lord, then what's meaning we give to doctrine of necessity? Now, at what stage you have come? A show cause notice has been issued. Explanation has been issued, that too backed by a statutory authority and, my lord, the order of division bench of the High Court. Now, what does Supreme Court say in such a situation? My lord, Honorable Supreme Court has said time and again, when a disciplinary proceeding is initiated, by itself, no punishment is imparted. Given, my lord. My lord, there is a judgment of the Supreme Court I just forgot. Sometimes we take a plea, my lord, that so-and-so is not by appointing authority. How come he has initiated this proceeding against me? The Supreme Court has said, my lord, if the relevant statute governing the condition of service provides that it is the appointing authority alone that proceeding has to be taken, Article 311 does not guarantee any such guarantee. It does not give any such guarantee. Because initiation of a proceeding by itself is not a prejudice. It is not a punishment. Only when, my lord, during the proceeding, some procedural part is not followed or an erroneous decision is arrived at, then, my lord, power of judicial review can be invoked. Merely because a show cause notice has been issued, merely because a disciplinary proceeding has been initiated by an authority other than the appointing authority, that by itself is not an illegality. Now, the Honorable Supreme Court, I rely upon two small judgments, my lord. Two small judgments, my lord. 1976, 3 SCC 361. 1976, 3 SCC 361. Please come to paragraph 5, my lord. Other obstacles in the way of granting the appellant relief were also ours before the High Court and before us. But we are not inclined to investigate them for the short reason that writ petition was in any case premature. No punitive action has yet been taken. It is difficult to state, apart from speculation, what the outcome of the proceedings will be. In case the appellant is punished, it is certainly open to him either to file an appeal as provided in the relevant rules or to take other actions as he may be advised or resort to it. It is not for us at the moment to consider whether the writ petitioner will lie or whether an industrial dispute would be raised or whether an appeal to the appellate body were invalid, issued a fresh memorandum which concluded the competent authority under the rules is proper remedy. Although these are issues which merit serious consideration. Now, my lord, an explanation has been issued. What decision would be taken will go on, my lord, hypothesis. It may end in his favor, it may not end in his favor, do not know. That's why it says, bring all the original certificates, all your experience certificates. Because our view is you do not have experience. There was no criteria of selection. Then my lord will kindly take the other judgments. 1996, 1 SCC 338. Para 7. Para 7. As rightly held by the learned single judge and division bench, no interference was called for at an interlocutory stage of disciplinary proceeding. Inquiry was no doubt over, but competent authority was yet to decide whether charges against the respondent are established either wholly or partly and what punishment, if any, is called for. at this stage of proceeding, it was wholly unnecessary to go into the question as to who is competent to impose which punishment upon the respondent. Such an exercise is purely academic at this stage of disciplinary proceeding. So for learned single judge is concerned, he did not examine the regulation, nor did he etc. So my lord, the preponderance of judicial view seems to be at the stage when a show cause notice is issued, Article 311 is not effective. That's the, my lord, underlying legal principle. Huh? And para 8 also, my lord. Please come to Placidum D. Accordingly, we dismiss these appeals without expressing any opinion on the correctness or otherwise of holding of the division bench with respect to powers of the managing director, the board or the government in the matter of imposition of so. We only affirm the view that learned single judge and division bench at this stage of the proceeding, no interference is warranted by the High Court under Article 226 of the Constitution. My lord, there is a doubt has arisen regarding your qualification, your experience, etc. We had taken a decision. While taking the decision, there was a violation of the principles of natural justice. It is only on that count, my lord, a relief was given to the petitioner. Now, division bench clarified, you need not hold the inquiry under the service rule. All that is required is, please issue a show cause notice, take his perspective, hear him, and pass a speaking order. If it is in his favor, is well and good. If it is not in his favor, a speaking order is called up. Now, at this stage, is this writ petition not premature? Why? In that case, my lord, lordship will have to interfere with each and every proceeding. Merely because a petitioner will come up with some plea that he is likely to act against me, he is having bias against me, etc., etc. So, my lord, to cut short the whole thing, this writ petition is nothing but the petitioner is trying to abuse the process of this honorable court, my lord. He is admittedly, he is having some problem. Now he has to satisfy the authority. And which he has done. He has filed his explanation. He has filed adjournment petition saying my son is not well. I'll attend on the next day. Instead of attending, he has came before this honorable court. Where is the averment in the writ petition? Where is that? Where is that candid disclosure of facts? That you have already submitted your reply. Not in a very, straitjacket. It has to be candid disclosure without being influenced by any other ifs and buts. It has to be an unqualified statement. It's not there. Therefore, my lord, apart from anything else, the conduct of the petitioner is something which your lordships will definitely look into in this case. Therefore, my lord, lordships will vacate the interim order, dismiss this writ petition by awarding exemplary cost. And my lord, my learned friend is saying that page 39, he is having some bias against somebody. My lord, will remove them. Page 39 of the IA. He says, my lord, Mr. B.L. Chaudhary has done this, that all right. So Mr. Chaudhary will not be there. We have the instruction to make the submission also. Page 39. This is the committee, my lord, which will examine the matter of the IA.
Of the IA.
Yes. Now he say he has alleged something against this person at serial number 1, B.L. Chaudhary. So, my lord, if he is having done, we'll remove him. He will not be there in the committee. If that is coming in the way, we'll remove him. Anyways, we have the instructions to make that submission. But he has already submitted to the jurisdiction. Now he must face the consequence in law. So therefore, my lord, to sum up, my arguments are very simple. This is a writ petition, which is not at all an honest attempt to, my lord, redress somebody's legitimate grievance. If you are so sure about your, certificates, eligibility. Why are we afraid of facing an inquiry? Should be happy. All right, you do it. You'll supply. If tomorrow authority doesn't accept, you come to the court. But not like this. You can't preempt an authority from taking a call. That too, when that call has been Milord approved by the division bench of the High Court. So, my lord, my learned friend's entire argument goes against runs counter to the division bench direction. He can't say, I accept division bench, but this is wrong. No, we are not doing anything other than what has been ordered by the division. We have only tried to do what division bench has permitted. And now the decision is not taken. So explanation called for, explanation submitted, adjournment sought on the ground of son's illness. Then on twice he took adjournment, my lord. We have accommodated him on 2 occasions. Now you can't come to court saying that this is wrong, this is bad, this is right. This is my humble submission, my lord. Deeply obliged. Lordship's kind permission will back.
My lord, perhaps, my lord, I do not like to make such submission, my lord. My learned friend has not been properly briefed, my lord, so far as the conduct of the petitioner is being assailed. Because, my lord, it has been submitted that, my lord, many things have not been stated about the filing of the written response to the show cause notice and, my lord, filing of application for adjournment. Your lordship will kindly take up my petition. Because on that, my lord, it has been submitted that, my lord, the petitioner has not come up before this court with clean hands. And therefore, equity is not in favor of the petition. That is the sum and substance on this point that my learned friend has submitted, my lord. He has either not read the brief or, my lord, he has not been briefed properly. Your lordship may kindly come to page 13, my lord. Because his submission is that the fact that I have filed there, my lord, show cause reply that has not been stated, and that, my lord, I have made an adjournment petition and submitted to their jurisdiction that has not been submitted is very clear. Your lordship will come to page 13, paragraph 22. That the petitioner proceeded to submit his explanation reply on 10/7/2024, stating his entire credentials for the post of Professor Bhupen Hazarika School of Mass Communication. In the interest of brevity, the petitioner craves leave of this honorable court to furnish a paper book of the reply, and that has, my lord, I have already said that bunch, my. So I have clearly stated that I have submitted my reply. And you are questioning my conduct. Thereafter, your lordship will see that pursuant to the reply, the petitioner was asked to appear for a personal hearing on such and such date. That, my lord, I have annexed. That on account of the petitioner's son's health, the petitioner was constrained to apply for a postponement of the personal hearing, to which the respondent university was pleased to agree. That letter I have annexed. Where is the, my lord, suppression? And without reading the brief, my lord, you question my conduct. So far, my lord, that point, my lord, my learned friend had been repeating that, my lord, is a court of equity, and I have not come before the court, before this court with clean hands is false true. Now, my lord, the first submission my learned friend made, and my lord, he made with, my lord, full long power, that, my lord, my lord, retorting to my submission that if any deviation is shown, that I'll be out of court, I'll be non-suited. And he had referred to, my lord, page 76 of the UGC clause 5. Your lordship will kindly read it again, my lord. That, my lord, the paper that has been given, my lord, the UGC guidelines, because he was relying that, my lord, this has not been followed. And on this ground itself, my lord, I have to be non-suited. Page 76, my lord, clause 5. He was harping on this. In the case of selection of faculty members who are from outside the academic field and are considered under clause 4, 3b, and etc. of the regulation, the university statutory bodies must lay down clear and transparent criteria and procedures so that only outstanding professionals who can contribute substantially to the university knowledge system are selected. And my submission of my learned friend is that, my lord, this has not been, my lord, formulated. Therefore, the selection is wrong. This is the crux of the submission on his point. Now, my lord, to this, he has also said, my lord, even the format, because I have stated in the petition that for, my lord, the applicants under clause A and clause B is the same format. Format has been prepared by the university. And now they pretend to not to know, my lord, who has prepared, when to prepare, we do not know. But it is the university, they have prepared. And, my lord, the procedure, because this is a, my lord, regulation of 2018. And your lordship would kindly come to the writ petition at annexer B at page. Page 28. You have already laid down. Manner of appointment. Clause B. You have already laid down in the, my lord, the first statute. In fact, my learned friend was relying on the statute. I do not have a copy of the statute, but this extract I have got, my lord. It is clearly said, my lord, the university shall advertise the post with such qualification as have been prescribed in the ordinance. So they have issued the advertisement pursuant to their ordinance, following their ordinance. The applications received against each post shall be sent to at least 2 outside experts not connected with the university for assessment of their eligibility for the post. You have got a panel of experts, you have sent it to them. That is the procedure you have laid down. Then, clause 4, the shortlisted applicants will be interviewed by the selection committee as prescribed. For the purpose of selection committee will recommend the names in order of preference to the board of management. That you have done. This has been already laid down in the, my lord, in your statute. If you wanted to be elaborate, that is your problem, you did not do it. But for that, my lord, my selection cannot be, my lord, essay. And this is the way you have been selecting professors all through. And this has been in the my lord, your statute. So, my lord, it does not lie in the mouth of the, my lord, counsel for the university to say that, my lord, this clause has not been followed. 2018, we are in 2024, and they have not laid down any procedure. It is there in the statute. And I have dealt with that in my lord, show cause reply. Your lordship will kindly take the, my lord, this bunch. Page 22. My lord, submissions should not be made on superficial, my lord. I have taken your lordship's time because it was necessary, my lord. I hardly take, my lord, unnecessary time before your lordship knows, my lord, from last 40 years of my experience, my lord. I do not mislead this honorable court. I do not allow my petitioners, my lord, my client to give any false information or, my lord, concealing anything. Now, this has been taken, my lord, page 22, clause 40. That's, sir, the inquiry committee in paragraph 28 of its
22.
Page 22, my lord.
This book.
Yes, my lord. Page 22, last paragraph, my lord, 40.
Oh, there's no paragraph. Page 22, 52.
Page 22, my lord. Page 22.
Okay. Yes.
There are 3 paragraphs, 38, 39, 40. I'll read 40, my lord. That, sir, the inquiry committee in paragraph 28 of its report had observed that the assessment report itself are faulty and not based on verifiable criteria of UGC. Apparently, this observation was primarily based on its earlier observation under paragraph 17 to 21 of the same report. Now, my lord, your lordship will kindly read the report. Para 17, the committee quoted from UGC regulation 2018 one assessment criteria prescribed for in-service teachers or teachers with past experience under clause 4.1.3a, not for direct recruitment or industry professionals under clause 4.1.3b, and stated that therefore it was necessary that the applications were screened based on publications and documentary evidence strictly on criteria notified by UGC via its table number 2 of the regulation, and also university in its advertisement. However, in the instant case, the same has not been followed. This is their report. Whereas the committee had in paragraph 15 and 28 noted that under subclause 5 of clause 6 of the said UGC regulation, the university may lay down clear and transparent criteria for selection under the clause 4.1.3.b, which was clearly done for selection of all the 3 posts of professors in School of Mass Communication, Humanities, so and so, may, which is clear from the assessment report appended at page 20 to 33 of Annexure D to the instant submission. It is here, my lord. The irrelevant table 2 of the said UGC regulation was cited apparently only to establish that the screening process was faulty, which is not applicable. That has been cited to show that the selection is faulty. Then, my lord, next para, that sir, paragraph 18 and 19 of the inquiry report primarily dealt on the process of screening by 2 outside subject experts, their eligibility to screen the application and their integrity to establish that the screening process was faulty. Before recording the observation, the committee had arrived at the conclusion that the 2 candidates called for interview were actually not meeting the eligibility criteria. My lord, this is everything is predetermined, my lord. That is what is clear from their report. And my lord, they say that we have not taken any decision. We are yet to take a decision. As the committee believed that the assessments were done without going through the sufficient document, it was because the committee was misled to believe that I had submitted only those documents which were provided by the registrar KKHSU. It is, however, surprising that the committee did not call for all the documents submitted by me through online, though it was aware of it. So, my lord, these documents I have entirely, my lord, submitted. Before the committee, it was not submitted. And therefore, my lord, committee comes to a different conclusion. Then next page, paragraph 41, your lordship will read, kindly, my lord. That, sir, inquiry committee in paragraph 28 of its report had observed that the application of Dr. Jayanta Kumar Sharma could not have been and cannot be considered under this criteria, clause 413b of the regulation 18, since except having PhD degree, there is nothing on record to prove that. This was the report. Number 1. A, he was an outstanding professional who had made significant contribution to the knowledge and concerned allied discipline. B, there is no documentary evidence that he had made significant contribution to knowledge in the area of mass communication. My humble submission in this regard is that I had submitted all relevant documents online, and 2 subject experts chosen by university had expressed their opinion apparently contrary to the opinion of the inquiry committee, and I was invited for the interview and offered an appointment. In this entire process, I was not a party, and the university had followed the procedure designed and created by it. All my claims in my application were true, and my mere claim for a post does not make me guilty if I am selected and offered an appointment. My lord, I have also read, my lord, given all the reply in paragraph 42, my lord. The inquiry committee in paragraph 28 of its report had observed that he was working as PRO and PRO, my lord, the public relation officer is sought to be, my lord, downgraded and looked down upon. That is what is required, my lord, in an expert, and that is utilized in the university. PRO and PRO has job profile in railways was different than the job profile of a researcher working in a research institute, or a professional developing policy document or bringing new inventions or adding to the knowledge of the discipline. There is no evidence to prove that he had obtained any research project or developed any new teaching, learning pedagogy, or produced any policy document, etc., so as to be considered an outstanding professional. In this regard, it is my humble submission that all the above criteria were nowhere recorded to be essential by UGC regulation 2018 for recruitment under clause 4.1.3.b and were actually invented by the committee. Likewise, my lord, next paragraph also I have stated. The UGC had rightly mandated that the industry experts should not be selected on subjective criteria and some objective criteria should be evolved by each university. In the present instance, the university had developed some objective criteria as evident from the format of assessment by the 2 outside experts. That format you had prepared. It is not that this format was developed for my recruitment only. The same format was used for recruitment of 2 other professors in the university in the School of Humanities and Social Science, which may be perused from the documents appearing at page so and so, so and so. It is pertinent to note that Professor V. Krishna Anand, who had screened the application for the post of professor in Bhuban Hazarika School of Mass Communication, had also screened the application for the post of professor of School of Social Science. So, my lord, the same person, you are accepting him in one. In the other case, my lord, you have not done anything. Why this discrimination? So therefore, my lord, that submission, my lord, of my learned friend falls true. So firstly, my lord, he said about, my lord, the clause 5 of the first schedule. I have shown, my lord, I have given the reply, and also, my lord, the first statute I have drawn your lordship's attention to. Now, my lord, he has submitted about my lord, the inquiry report. Your lordship may kindly take up the writ petition, page 22. Sorry, page 2 of the report. Inquiry report.
40.
Sorry.
Page 40.
No, your lordship may kindly come to page 35, my lord. I'm sorry, my lord.
You on the inquiry report?
My lord, this is this page page 35, my lord. This is relevant, my lord, to be read once again, my lord. Page 35. This is the proceeding of the selection committee. There, my lord, there were two experts, Professor V. Krishna Anand, Professor Abhijit Bora, and my lord, chairman and other members. The two candidates were shortlisted and called for interview, out of which two candidates appeared in the interview. The committee, after taking into consideration the academic credentials, experience in ODL, research publication, and performance in the interview, unanimously decided to recommend the following candidates. And this has been signed by 1, 2, 3, 4, 5, 6, all the persons. Now they want to say, a fresh committee wants to say that, my lord, this is not correct. Page 48, my lord, of the inquiry report, my lord, only conclusion part of the inquiry report, which was not signed by one of the members. Only one person signed, Dr. Mridul Hazarika, page 48, the conclusion. My lord, at the cost of repetition, my lord, I'm my lord, taking your lordship's time, but it has to be read again, my lord. Conclusion, based on the above observation, the committee is of the opinion that Dr. Jayanta Kumar Sharma did not fulfill the eligibility conditions. In spite of, my lord, all this that I have shown. Now, my lord, the third submission that my learned friend made was that, my lord, doctrine of necessity. Now, my lord, the division bench order, my lord, your lordship has seen, and we are bound by this order. Division bench has said that give him adequate opportunity. Division bench in not so many words said that the procedure has to be fair. Without the division bench saying, or without the court saying, my lord, the procedure has to be fair. And what they have done, my lord, as I have already told, my lord, one person gives committee, my lord, board of members gives a report against me. Then, my lord, he sits in the committee. Then he will sit in the board of meeting again. My lord, the same report. That cannot be compared with a, my lord, judicial officer framing charge and giving, my lord, taking the trial. This is not a comparison, my lord. It has to be fair, man. That is the primary requirement of any proceeding. My lord, the reasonable opportunity and, my lord, fair. Will it be fair, my lord? And, my lord, the submission has been made that, okay, you have got problem with some of the members, we'll remove them. If you remove them, what happens, my lord? Your lordship will kindly see the committee. Page 103. On this, my lord, I have got two submissions to make. Firstly, your lordship will come to, my lord, page 103. Before this committee, I am supposed to appear. Now, there are 5 persons. And there are 3 board members. So, my lord, since the report will go to the, my lord, the board of management. So, my lord, these 3 persons will be removed. And what will remain, my lord? BL Chaudhary, he was also a member, 1, 2, 3, they are member. Then one UGC official who is not named. Then, my lord, one subject expert, not named, and my lord, deputy registrar, administration. So, my lord, this committee will be constituted by a single person. And my lord, to submit that, he says, my lord, I have got instructions to make this submission, we'll remove these persons. That means, my lord, you admit that, my lord, the committee was not properly constituted. On that ground itself, my lord, this order has to be set aside. You constitute a committee without naming the persons, you call me on a particular date, I pray for time, you give time, that is fine, my lord, but even now, we do not know, maybe the university doesn't know. When the date is fixed in the morning, perhaps, my lord, they'll call someone over telephone, hello, Mr. So-and-so, please come, we have got an interview. Is that the, my lord, way of, my lord, constituting a committee where my livelihood is at stake? That's how, my lord, that's why I've challenged this, my lord, order of constitution of the committee. Then, my lord, the other submission that, my lord, this committee will be incomplete. And then, my lord, I have shown that, my lord, everything is predetermined. The initial committee itself has held that my selection is bad. Now the same members are there in the, my lord, committee before whom I'll appear. So it will naturally hold it. And it will be placed before the board of management where these persons will be there. Is this a, my lord, inquiry? Therefore, my lord, my submission is that, my lord, this selection of the committee, my lord, cannot stand, and therefore, my lord, your lordship will set aside. It has to be fair, my lord. This is unfair, my lord. The bias is, my lord, on the face of it is very clear, my lord.
Say, Chaudhary himself defended my case in 2022.
And, my lord, I have shown, my lord, this person, if your lordship kindly comes to page 50, last submission, my lord, I'm not taking 2 minutes, my lord.
Page 50.
Page 50, 50. In pursuance to the decision of the, I'm sorry, my dear. Decision officer order, in pursuance to the decision of the 71st meeting of the Board of Management held on 19 April 2023 by the resolution number such and such, and on the basis of the report submitted by the committee constituted for examination of the selection procedure and eligibility of Professor Jayanta Kumar Sharma, the services of Professor Jayanta Sharma, so-and-so, is terminated with immediate effect. This is, my lord, the registrar, Urujyoti Chaudhary. And this person, my lord, I have already shown, my lord, placed the documents before lordship. I did not get the opportunity to file by an affidavit. That, my lord, he has defended my case. When, my lord, complaint has given to me, against me, he has defended. He said that everything was all right. He has terminated me. So, my lord, everything is fishy in the, my lord, university so far as I am concerned. Therefore, my lord, nothing is fair. And, my lord, the division bench need not say that, my lord, the procedure, the inquiry has to be fair. Therefore, this, my lord, committee, constitution of the committee has to be set aside. This is my limited submission.
But MP Chaudhary also heard Mr. K.N. Chaudhary, learned senior partner. Assisted by Mr. P.K. Chaudhary.
1 to 3 and 4.
For the respondents,
1 to 3 and
5 also, I think. Up to 5.
I was
One,
not-
two, three, four.
this one
It's-
five
you-
only.
you-
5 is UGC.
And so 6 is you get 6. Then you are 6. MS. K. Barbajali, and council appearing on behalf of A. Chamal and Sunny Cox.
I'm a highly obliged, my lord.
Then, hearing.
May please, your lordship. My lord, this part had matter, my lord. Lordship may kindly recollect, my lord, that in a case of unauthorized absence, if a person is dismissed from service, my lord, in that case, I refer to at least, my lord, to one main judgment, Kusanbi Parman, my lord. Mr. Das, we'll take up some other day, not today. No problem, no problem. As per convenience, no problem. Sorry, I kept. Sure. You understand, my lord, continuously taking all this hearing matter, my lord. Well, give a date. Yes, yes. All of, pom bhi thaka sa diok na, pom ke thaka. But Mr. VK Das, as well as the. DSTS. Fifth of November. Not on fifth any other. You were there convenient, 12th. 12th, give it. It's 12th of November. Well, they say, my lord, because I wanted to prepone on 5th. 5th, I have it's been on. Or 7th, my lord, 7th, because it is 7th, oblige.
Leather.
Made peace, your lordship. So this is the matter also as part of last order, I was required to provide a proposal, provide the guideline for the departmental promotion committee, lordship. On that, lordship, I have received specific instruction, lordship. I will read out that I have the honor to inform that no separate guideline for conducting of departmental promotion committee have been found as per record. This is from the department, lordship. However, lordship, the minute and the these rules, Assam Food and Civil Supply Rules 1970 has been attached. And what is there in the rules, lordship, and we already know that. No, Mr. Barua, lordship. The last order, you asked to produce the records. Record means not other records, the record, the guideline actually, not record. No, no, here, have you seen the order of 11/9/2024? But no, 11/9/2024, have you seen it? But it says Mr. Sikesh Barua, the governor advocate Assam. Because yes, I remember. The word records is in the order because at that time I submitted that the record was not available. But thing is that it is not the record, it is basically the guideline of departmental promotion committee, if I'm not wrong. That is only the guideline. Then as well as the order dated 6/6/2012. Yes, those orders are with me. Passed by this. Yes, it is not 6/6/2012, it is 6/6/2011. Okay. I have taken out, lordship. There are two orders. And by pencil also, I have written all the common cases. It's a common judgment for so many cases, lordship. I have by pencil, I have noted it. And those order, that order is basically in regard to, lordship, conducting of a written examination which was not been satisfied by the party. It is a judgment of Justice Vicky Kotoki. Okay, what did it matter? Two. Because these judgment interpret, that is the thing, that is why, lordship, this direct recruitment, they got selected in the year 2012, and this promotees got delayed by 1 year in 2013. This is the rules, lordship. The rule says that promotees. You've not made your argument yet. I have already made my argument on the last of the. I have not made my argument.
If I may be permitted, your lordship, or on a date,
Or
I'll leave it to your
I can make fresh argument, lordship, not a problem. I can log up to refresh, lordship.
On a different.
Yes, yes, lordship, not a problem.
What you say?
AR Google also.
AR.
AR Google.
AR. Okay.
See, 7.
Authority to the case under the document. For the respondents,
I'm for the reference number 4, 5, and 8, your lordship.
one minute.
Yes.
I am for the government respondents. State council.
For the respondents. One and two.
1 to 4 only.
One and two. As Mr. M. Sharma.
1 and 2, lordship.
4, 5, and 8, your lordship. And 8.
I am for 1 and 2.
It's the method for. But it's. We need it.
If I may, your lordship, can it be fixed on the 7th, your lordship? 7th?
7, one part is already fixed.
Yes, lordship, on say on any other days, out of 7, because I think that will consume that.
Then let it be on the 14th, your lordship. Thursday, we will hearing. Obliged.
You said those order loss make it. Mas over.
On the other side.
BTC and the SSA.
R. Majumdar.
I don't know, these for the elementary, but the main parties are the
RB Bora.
SSA, my lord.
SSC is required.
It's the Antanu Bora.
Who?
Antanu Bora.
Yes, Bora.
Yes, Bora.
Last occasion also, he was not here.
My lord, he's not here. Lordship can have it on some other day, my lord.
On his request.
My lord, he's not told me, my lord. I'm appearing for the elementary education.
How about the BTC? PTC is also
PTC,
important.
yes, madam.
Where's the BTC?
From them, my lord. One is, I'll just from them.
Okay, heard Mr. S.K. Roy,
And-
not a council.
And also, my lord, actually, in this case, my lord, considering the fact of the case, the nepotism is there, my lord. This honorable court was passed an order to, for an inquiry by the CM Vigilance and registered a criminal case against the headmaster and also the officers, right, in this case, my lord.
Lordship will have it on some other day, my lord. That day, let the councils be there, my lord, there, because they are a necessary party.
S.K. Roy, not a council. Well, it's Thursday. That's starting. None represents the PTC as well as the SSC. The court of this is the matter after 1 week, 2 weeks.
My lord, a date may be fixed, my lord, otherwise.
This is the matter again on 7,
7, my lord, November,
7.
Yes.
published.
13.
BTC 9. BTC 9. Lordship, in this matter is pertaining to the provincialization of service of the petitioner, Lordship, the old matter, Lordship. But BTC is the party, is the necessary party here.
To the BTC,
Uh,
you are appearing for?
they're the private parties.
Number 8 and 9.
And
And Mrs. Bora, is it ready?
yes, Mrs. Bora appearing last time. Can I?
Third, next step.
AU Ahmed.
As well as H.S. Sarkar.
H. Sarkar is not, I'm newly appearing, my lord. He is not well, as not.
Yes, now. Learned council, what is one number, 8 and 9,
8 and 9.
none appears. When do you want?
Maybe my lord.
After 1 week, any date.
No, my lord, maybe second week of November, my lord. Maybe on
No, before that, Lord,
14th.
in the old matter, 2015 matter. Lord.
12th November.
12th, yes. Right.